My lordships, I beg to mention item number 4, my lordship. And for the appellant here, my lordship, this matter is listed on Tuesday, this coming Tuesday,
Next Tuesday.
this coming 10th.
This is DB matter.
Yes, my lord.
We have decided to sit on Monday,
Monday.
only on Monday. Can we fix it on Monday, next Monday?
Okay, my lord.
And the update being made by Mrs.
Yeah. Monday.
Learned counsel for the learned. You are for the respondent.
No, my lordship, appellant.
Appellant. Oh, yes, appellant. You inform the other side.
Yes, sir.
I am for respondent.
Place the matter on next Monday.
My lord, may I please to mention the WPC, WA 18 to 2024, to
When?
list on
When?
10. 10 is not possible, I think. 9 then, Monday, 9. Unless.
May I please, your lordship? So in this matter, earlier occasion, I was directed by this honorable court to submit one additional affidavit. So I have filing additional affidavit. So here, my lord, in the last occasion, the question arose that tender paper was not annexed herewith, but in fact, under RTI, we were not provided tender paper. But one communication letter they provided, Lordship may kindly peruse page 204, Lordship. My additional affidavit 204, my lord. This is the reason why the PIO cum executive engineer didn't provide us the required tender paper of the contracting firm. May I read, my lord?
Yes.
Yes. To the executive engineer, Public Works Department, Zamin Division, Palin, subject an intimation letter regarding the disclosure of my related documents to any RTI activities. Respected sir, it's learned that an RTI has been placed under your good office seeking contract agreement and other relevant documents of MS BM Enterprises against the project CO from Tabia to Yangte under Gangte Circle, Karadi district, 5.22 kilometers. Since I have not yet received any payment against said project, hence I requested your good office not to disclose any document to any RTI activists without any concern. Therefore, this is for my kind information and necessary action. Please, I shall oblige to your kindness. So this is the reason. But they have given us draft NIT and DPR, everything. And that apart, one budget allocation letter also they have submitted us. According to budget allocation, all the necessary sanction of the project road has already been completed. Now, the road is yet to construct. That's why they are trying to deviate the site of road construction. That's why we the local people are apprehend to deprive from getting a good road communication and transportation as in the very backward place. So this project is blessing for the locality, but the respondent authority in association with the contracting firm, they are trying to divert the road construction and fund allocation, my lord. So at this moment, Lordship may be kind enough to issue at least notice at this moment, my lord.
Mr. Ratam, there was a direction of this court
Yes, my lord.
dated
In fact-
8/11/22.
Yes, my lord. In
Have
fact,
you obtained any instruction?
yes, my lord. In fact, what was intended by this honorable court, when was the commencement of work? When is the completion date, my lord? That was to be submitted, my lord. Because for that, I have got the instructions, my lord. So, my lord will see acceptance of the work, acceptance and award of work was on 30th August 2023. And second page is the commencement of work, my lord.
Hmm.
It is on 5th September 2023, my lord. And then this is a part of agreement, my lord. In the last page, my lord. Agreement amount, performance, stipulated period of completion 36 months, my lord. Date of completion is 5/9/2022. Date of commencement is 5/9/2023, my lord. Now, my lord will kindly see at page 191. Just within 2 months, the complaint has started, my lord, saying that road is not been constructed as per DPR. It is still ongoing, my lord. Date of completion is 5/9/2026, my lord.
Hmm.
It is still ongoing. There is no deviation, nothing, my lord. And in fact, it seems that the petitioner is directly after the contractor, not for the construction of road, my lord. He seems like he is after the contractor itself. And in the interim prayer, also it is for the stay of the construction, my lord. Whether that is a public interest or not. My lord. Because now it is the still an ongoing project. They have to complete it till the before the completion date, my lord. Now at this stage,
So
saying
date
that
of commencement is
5/9/2023.
5/9/22.
So it's a ongoing. They are doing the work. It is ongoing as per my instruction. And date of completion is 5/9/2026, now 36 months. And he's alleging of siphoning of money, my lord. It's an ongoing project.
Mr. Deca, is it not premature that this is?
My lord, my additional affidavit, last page 205, my lord. This is a certificate of budget allocation. And according to this document, the physical target has been complete. The complete that completing that is 100% 2023-24, my lord. So though the respondent says that the project is going on, as per DPR, it was started just road cutting. That is also not from Tabiar to Yangte, but it is Iorte to, they are starting from Iorte, leaving 3 kilometers from the 0 point Tabiar. So there is something fishy, my lord. So letter itself, the communication letter itself indicates there is something fishy, and this budget allocation certificate, according to this, it is their document, my lord. So according to this, physical target in 100% in the year 23-24. 23-24 has already left, my lord. They are not just, they are starting Yes. 31st March 2024, it was
No,
targeted as per the budget allocation
Mr.
certificate.
Deca, as per this agreement, at page number 3, submitted by Mr. Rotam. The date of commencement is 5/9/2023. And date of completion is 5/9/2026. Are you disputing this agreement?
Yes, because it was not given, not submitted as by the respondent. It may be prepared at any moment, at any time. So this is,
My lord, in fact,
it
what
was
my
not up-
learned friend is trying to say, by the communication of one MSBM enterprise not to disclose his documents. My lord, on what context these are given, my lord? In fact, what I have come across, my lord, whenever RTI applicants, they file RTIs, which asking for disclosure of personal documents. In that event, the consent of the person, individual is taken, my lord. In this
Required to be
case,
taken.
yes. In this case, whether to disclose or not, these personal documents, which are in exclusively the personal documents of that individual, my lord. Those are without the consent cannot be disclosed, my lord. Now, they have not shown what documents they have asked. I believe this intimation letter is in respect of the personal documents of that particular firm, which are beyond the purview of disclosure. It is attracted under section, I believe, section 8J of the RTI Act. Consent has to be taken from individual. Now they are saying, showing this as if to portray that no tender document was furnished only on this basis, man. No information was furnished only on this basis. What type of information were shown? They have not shown, man. What RTI application they have filed? It is not there in the record.
we were sought for only tender papers and DPR. So DPR already we have obtained. But the present stand of the respondent is very recently prepared to defend themselves. But still, there is every hope that the road will be not constructed. So our motto is to complete the road construction as per DPR, my lord. If road is constructed as per DPR, then the people will get the benefit, my lord.
In fact,
Otherwise,
as per the
There is
Guwahati High
no hope
Court
of constructing road.
PIL rules also, every particular has to be stated, my lord. They have just come up with a DPR and this intimation letter and alleging that there is no construction, road is deviated, my lord. This type of PILs cannot be entertained in the fire. Even issuing notice, it becomes a tool just to pressurize the contractor or something, my lord.
No,
Okay, all right. You file one status report on next month. Please.
Yes, status report that
yes,
For Mr. Yabeka, learned counsel for the petitioner, and Mr. Anuragha, learned additional advocate general for us. Pursuant to order on this court dated 8/11/2024, Mr. Ratan, learned additional advocate general has obtained necessary inspection and placed the same before this court. We have taken note of the written inspection received by Mr. Ratan. And having considered all the facts and circumstances, it is provided that Mr. Ratan shall file one status report of the project before this program next month.
let it be in the month of January, my lord.
January.
Monday status report. on Monday. That next Monday.
Oh,
Oh, bless.
Item number 2.
Where your lordship? Lordship, here inadvertently, the union has not been met as one of the party respondent. So I'm seeking some time for filing IA for impleting the
The-
union.
Lease is between us and Neris, my lord. The Union of India is not even a necessary party.
Union of
My
India
lord
was-
Justice Nair will recall this case. This was a case, my lord, the Neris, my lord, on their own volition, my lord, gave an assurance before this honorable court, and it was in that terms this honorable court passed an order to implement something. Now they did not do it. Thereafter, we have to again come back before your lordships, and accordingly, in terms of the earlier order, my lord, this impugn order has also been passed. In fact, Justice Nair was very at the in single bench for many occasions.
So when do we want?
Your lordship, I'm seeking some time for filing an IA
When?
so as to implement at least a week time, your lordship.
Week 10.
Lordship.
Yes, Mr. Pangi?
Is in
I don't. I leave it to your lordships, but otherwise, it was on their. The appeal itself apparently has no merit, my lord. Because the earlier order was not put to challenge. That has attained finality. Now it is in terms of that order, this impugn order has been passed.
because in the original writ petitions, union was one of the party, your lordship.
Can't change the
So-
facts, but
Direction was given to the nearest as well as the ministry, your lordship. So therefore, I would like to implement
Okay, we will list it next week,
lordship
next Monday.
next Monday, lordship.
Third, Ms. Anandro, Learned Counsel for the appellant, and Ms. Leandro, Learned Counsel for the respondent. Ms. Onjo, Learned Counsel for the appellant, press for granted R189, here is allowed. Yes, is a list the matter on next Monday.
Lordship, name of the standing council may be reflected in the cost list, Mr. A. Apang. Standing council,
Apang.
nearest, your lordship.
Ms. Onjo submits that the name of the standing council of the appellant has not been reflected in the of this. Resistant legality.
Obliged.
May I please, Lordship?
Yes,
Lordship, this matter is pending more than 1 year, Lordship, for survey submitted of respondent number 2, Lordship. So this matter may be leased for the hearing, Lordship.
Service not completed yet, Your Lordship.
service
Service not complete yet.
not completed.
Yes.
Respondent number,
Two,
Two, Lordship.
respondent number 2 is the victim,
No,
Yes, sir.
it's a complainant, Lordship.
complainant. So step was taken through your office.
Not, no, Your Lordship. It was through register post. Your Lordship, let them direct to take steps through PP
Yes.
office. Yes, Your Lordship.
Fresh step has also already taken, Lordship.
No, you in view of judgment of division bench in
Deepak Nayak case. Deepak Nayak, your case.
you have to take step through the office of the people.
Uh,
You submit your notice to the respondent in the office of the PP.
yes, Lordship.
To jurisdictional PS, Your Lordship.
Yes.
Yes.
Heard, Mr.
HT Tara, Lordship. Honi Tana Tara, Lordship.
Learned counsel for the appellant and Mr. Itel learned additional PP for the state respondent. Office note dated 38/11/2024 indicates that service report in respect of respondent number 2 yet to be received. The learned counsel for the petitioner submits that he has taken step upon the respondent number 2. But Mr. Ite learned additional PP submits that the step was taken upon respondent number 2, not through the office of the PP, state of Arunachal Pradesh. Under such circumstances, it is provided that in view of the observation made by a division bench of this court in Deepak Nayak
Deepak Nayak.
versus state of
Assam, Your Lordship.
Assam. Citation,
Your Lordship, citation, Your Lordship, I will give the citation, Your Lordship.
the counsel for the appellant shall take fresh step upon respondent number 2 through the office of the public prosecutor, state of Arunachal Pradesh, within a period of within 2 working days from today. Upon receipt of such a notice, Mr. Ite learned additional PP shall cause service of the notice upon the respondent number 2 through the officer in charge jurisdictional PS and shall place a report before this court on next day. Leaves the matter on
After 3
which PS.
Your Lordship, it's Balapung, Balijan PS, Your Lordship.
Balipung PS.
Balipung
Lordship.
PS,
West Coming District or
West Coming District, Your Lordship.
3 weeks.
Yes, Your Lordship, after 3 weeks.
Leaves the matter after 3 weeks.
Deeply obliged, Your Lordship.
Your Lordship. This is an appeal against a judgment passed by the Special Court Council, whereby I was convicted. And I was sentenced for 20 years rigorous imprisonment. So I am before you challenging the impugned judgment.
Pardon?
So I am before this court challenging the impugned judgment which was passed by the Special Court Council. May I read the relevant part of the judgment?
Who is for respondent number 2, 3, and 4?
Lordship, legal aid counsel was
Legal aid
appointed,
counsel
Lordship,
was
but
appointed.
she has given her letter of absence till 14th of December. In the court list, it is reflected.
Till 14th of December.
Yes, Lordship, this
Cost.
Jaya Doji. The legal aid counsel.
Suggested that When can it be listed?
It's actually difficult. Can it be on January? Pardon, 29th of January. January last part, 29th
29th of January.
January.
Or Mr.
DK.
D.K. Devi, Learned Counsel for the Appellant, and Ms. L. Again, Learned Additional PP for the state respondent. Ms. Hagi submits that the legal aid counsel for the respondent number 2, 3, and 4 is absent today. And she has submitted letter of absence. And in view of above, it is provided that her assistant leaves the matter on 29th of
January.
January.
Public.
May your lordship.
Yes,
Lordship, item number 30 is supplementary hearing, your lordship.
item number,
3030. Your lordship, may I pray this matter may be listed on 9th of this month, your lordship. I'm for the respondent number 1. Consent has already been taken, your lordship.
pardon me?
No, my lord.
Are you for the petition?
I am for the petitioner, my lord.
Acha. Any objection?
My lord, since the council, my senior council, I'm accommodating them. Otherwise, there's urgency in the case, my lord. It's related to person with disability.
9th of December.
9th of December, lordship.
Ms. N. Anju, Learned Counsel for the respondent.
Number 1.
Respondent number 1, with consent from the other side, price for listing the matter on 9th of December. Fair, Lord.
Deeply obliged.
Is
May I
there
sum-
any interim order? No.
My lord, there's an interim order, my lord.
Okay,
Yes,
interim order pass earlier shall continue. Yes,
Yes, I am. I beg to mention item number 20, my lord. With the consent of other side, my lord, may I pray this be listed after 3 weeks, my lord.
Mr. Tagum, you are,
I have informed him, my lord.
you have no objection?
My lord, all right. We have filed the affidavit also even.
Mr. L.
Private,
Patel, Learned
my lord.
Counsel for
Private
the applicant.
respondent.
This is IA.
Hmm.
IA
No.
240.
20, my lord.
My lord,
Item
20.
number 20, my lord. I mentioned
20,
20, my
okay.
lord.
And the private respondents there, whether step upon private respondents completed or not, it's not confirmed in the item number 20. Private response.
Completed.
No, not sure, my lord.
That we have to see, my lord, in that case.
Item number 24. So edit card in respect of respondent number 7 has been received after
My lord.
service completed.
Completed.
So we'll director essay to list the matter for admission.
My lord, my lord.
Mr. L. Parnell, Learned Counsel for the petitioner with consent from the other side, best for listing the matter. When?
After 3 weeks, my lord.
After
3 weeks.
3 weeks. Here, allowed. Office note dated 29/11/24 indicates that service upon respondent number 7 has been completed. In view of above, it is provided that residents shall list the matter after three weeks.
My lord. Deeply obliged.
In the admission column.
My lord, I may kindly continue the interim, my lord, interim order.
Interim order passed earlier, shall continue.
But I make to mention item number 29 also, my lord, 29, my lord.
29.
29, my lord. Here also, my lord, with consent, I have informed the other side, my lord. This be listed also after 3 weeks, my lord.
L. Parnell, Learned Counsel for the appellant with consent from the other side, best for listing the matter after 3 weeks.
3 weeks.
Fair.
Highly obliged.
Mayor, my lord, I would like to mention item number 31. Matter is fixed for supplementary hearing. My lord, I am for the appellant. So,
What's
matter,
the one?
Your lordship, the matter may be fixed on 9th of this month.
Monday.
Any objection?
No.
No. As read for by Miss Yogote,
T-set,
learned counsel for the appellant. Appellant or respondent?
appellant,
Appellant. With consent from the other side, press for listing the matter on 9th of December. Chair Lord.
Obliged.
My lord, I'd like to mention item 28,
Item number
28, 28,
20,
28, 28,
20,
28.
28.
My lord, here in this figure, petitioner doesn't want to press more, so I would like to withdraw the petition.
No objection.
Mr. M. Nebo, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Here is accordingly allowed. This WPC number so it's just disposal on withdrawal.
Obliged.
Most obliged.
Kindly please, Your Honor. And I beg to mention item number 2.
Item number
2.
2.
Yes, Your Honor. And in this case, senior counsel, Mr. M. Purton, is unable to be present today before this honorable court. So this matter may kindly be taken up tomorrow, Your Honor.
Tomorrow.
Tomorrow.
Your good name?
T.Y. Bhutia.
Nice. So learned counsel appearing on behalf of Mr. M. Purton. Learned senior counsel for the petitioner, press for listing the letter tomorrow. Fair Lord.
Deeply obliged.
My lord, here also, in this case also, this matter has become infectious now. Also, it's not necessary to proceed further. So this,
Want to withdraw this?
yes,
Withdraw this
yes.
matter. Mr. M. Nebo, learned counsel for the petition, submits that he has the instruction to withdraw this petition. Here is allowed. Yes, WBC number services as a disposal of the
Most obliged. 3.
3.
Three.
Item number 3.
Oh,
Well,
This is for election commission.
yes, my lord. I have taken some instruction, my lord.
Yes.
The issue here is bit complex, my lord. My lord, I will furnish one copy, my lord, for proper appreciation of the facts, my lord. No, my lord, there is a state notification, my lord. State notification, my lord, where it has been earmarked for videos for 2 categories of personnel, 2 categories of employment. My lord, may see the box, my lord, index, my lord, district, my lord, and blocks earmarked videos of RD department, my lord. Blocks earmarked for circle officers. So, my lord, may please come to serial number 6, my lord, Kurungkumei district, my lord. Kurungkumei, serial number 6, my lord. Yes, my lord. Now, my lord, this one video, category of videos is for the department of RD department. One is to be held by the circle officer, my lord. Now, my lord, may please come to serial number 19, my lord. Of serial number 6, my lord.
Rami,
Parsi Parlo, my lord. 19, my lord. Damin, other side of the Damin, my lord. Parsi Parlo. On the top, my lord, it is the post, Parsi Parlo, the post of video. Parsi Parlo is earmarked post circle officer, my lord. My lord has seen on the top, my lord. Blocks earmarked post circle officers, my lord. So this post, the post of video, is by default has been given to the circle officer, my lord. Now, problem arises, my lord, here, my lord. My lord, may please come to page 4, my lord. Page 4 now.
yes.
Page 4, my lord, this one Bengia Raja, my lord. He has been given the charge of CO cum video, my lord. By the Department of Personnel, my lord. My lord, may kindly appreciate this post. The post of video is by default to the CO, my lord. Circle officer. It has to be held by the circle officer. Now, this Bengia Raja has been appointed, my lord, as an additional charge of CO cum BDO, my lord. Again, my lord, page 5 also, my lord, there has been some communication, my lord. And page 6, my lord, there is also a WT message by the secretary personal, my lord, to the DC Colonial, my lord. Now, page 7, my lord. For non, my lord, this order, my lord, may I read, my lord? Of 26 March 2018, my lord. In pursuance of order passed by the Guwahati High Court, my lord, there is some involvement of writ petition number 102 of 2018 also, my lord. Whereby, and as directed by the government letter so and so, the joining report of Sri Bengia Raja is accepted, my lord. For non-giving of the charge, my lord, he has filed a writ petition before this honorable court. So I have to go through this order, my lord. And then, my lord, what is the case, my lord, here is that the post of video is by default for the CO, my lord. Now, this person, Bengia Raja, is holding the charge of CO cum video, my lord. Now, since this post is for the CO, my lord, earmarked for CO, my lord. Now, by default, it is for the video also. He will also hold the post of video, my lord. Now, my lord, the petitioner herein is the APO M, my lord. APO monitoring, my lord. Now, he has been posted from some other district to the Parsipalo city block. Though, my lord, he is not the circle officer, my lord. So this is a bit a complex situation, my lord. So we need some time.
Who had created that situation? Who
Well,
had passed the transfer?
Yes, my lord. My lord, so why we need some time to examine the matter, my lord. So I have been instructed to take some time, my lord.
My lord, transfer order has been issued by the secretary, RD, the most competent authority.
My lord, may I kindly appreciate page 1, my lord. This post of video is earmarked for CO, my lord. The CO will hold the post of video by default, my lord. So this is for the post, this video post is for the CO, my lord. Now he is not a CO, my lord. There is some problem, my lord. We accept it, my lord. So we need some time to examine the matter and resolve the issue. So at least 3 weeks time may be given, my lord. If we can resolve the issue, my lord, the matter ends there, my lord. Because otherwise, my lord, he is not, my lord, eligible to hold the post of, my lord, video because it is for the circle officer.
He had already handed over his search in the other place.
Yes, my lord. We will look after his salary and all that, my lord. But still then, my lord, we have to examine the issue, my lord.
Okay, 2 weeks time, not.
Yes,
3
my
weeks.
lord. My lord.
But Mr. Debo, Lord.
My lord,
And.
my lord,
Sir, Lord, starting council, respondent number
my,
1, 2, 5, and 8.
my lord,
I am for 6 and 7, my lord.
6 and 7.
Yes.
Madam, you are for
So this for number 1, 2,
2,
3, 4,
5.
5 and 8, your lordship.
1, 2, 3, 5, and 8. Mr. Crystal, Lord, standing council for respondent number 6 and 7. Science that it will be granted at least 3 weeks time to resolve the issue. There is accordingly allowed. Rest is
my lord,
after 2 weeks.
my lord, in this regard, I was supposed to submit if court permits in this regard, because seeking time for certain correction, I don't see any reason for certain correction or adjustment, whatever council has stated. Transfer order has been made by the competent authority, and the Baloraja, the Bengia Raja, the respondent, the outgoing video has been appointed by the uncompetent authority. RD, Secretary RD is the competent authority to issue with the approval of the cabinet approval, and he has been issued, and the authority is well understood whom to post and whom to transfer back, and he has been transferred in the same place by the authority, competent authority, and there's what reason could be there for the further verification or other time is required? I don't understand this, and I pray that the court may not allow this because there must be some logical reason must be there. I am being transferred. I have already joined from my from the earlier posting. I have joined to the at Kurukme as a video. I have submitted my joining report, and thereafter they again says and my lord.
There. have only submitted the joining paper, not assumed search there.
No, no, I have not assumed the charge. That is other aspect. And this, my lord, I would like to say that this Bengaraja has been serving for more than almost 12 years at the same place. And he has been now, the petitioner has been placed in his place. So, and again, they are seeking
We are not
time.
concerned with that aspect. For how long he is serving there.
And APO, APO credit and APO monitor status also is the same. Rather, status of the APO credit is higher than that of APO credit.
Wait for 2 weeks. let
Yes,
it
my lord.
resolve
There
that.
is also a judgment of this honorable court that has to be examined, ma'am. Yes.
My lord, then 1 week time may be given in this regard.
2 weeks, my lord. 2 weeks time. At least 2 weeks.
My lord, just unnecessarily lingering.
Suggested that
My lord, 19, my lord.
19,
Yes, ma'am.
19.
Yes, ma'am.
19.
December.
Today is uh
19 December. 2 weeks only.
my lord, 1 week.
No, no,
There's no reason to
Because, my lord,
verify or
appointment of this private respondent has been issued by the secretary personnel, my lord. He has been appointed as CO and he has been posted as CO, my lord. And the post of video is by default for the CO, my lord. So there is some, my lord, departmental exercise has to be carried out, my lord.
my lord, otherwise the matter may be fixed for tomorrow. I'll satisfy the court that how far he is eligible. Even the eligibility is in the big question. He is not even qualified to hold the post of APO.
we will not examine that.
So otherwise, when the competent authority, secretary personnel has issued and the RD has already issued the transfer order and that has been, after joining, I am being holded for no reason.
Issue is, my lord, he.
Regarding High Court, as said by my learned counsel, regarding High Court issues, that is different aspects that he was not allowed. That was his
Okay.
problem.
19. 19.
My lord, 1 week. What? I don't see also reason for holding any further time.
So on 13, then 13 December.
13, my
Oh.
lord, at least, my lord,
Oh.
because there have to be some communication with the Department of Personnel, my lord.
My lord, this is transfer order is not made by myself. That is not made by the authority themselves. And the competent
So,
authority has well aware and that they.
There may be some mistake also.
Yes, my lord.
Let them.
So let the matter be fixed on 13. That's all.
13 will be too soon.
Otherwise, it will just they're trying to pull the time. That's all, as per my understanding.
We have to resolve it, my lord.
Mm.
We have to resolve it.
The result that can be made in a day or two also. Everything is at your hand.
So 2 departments are involved.
Yes, yes, my lord.
In the issue.
Yes, my lord.
My lord, all are sitting at the same secretariat building campus.
Okay, then on
13.
16th of December.
16, my lord.
Yes, next item.
My lord, 16, I have some personal difficulty. 18, my lord, 18.
18.
Yes, my lord. 18.
Okay, 18.
Obliged, my lord.
Obliged.
Please, my lord. My lord, here I'm basically challenging the NIT, man. The manner in which it has been floated, man, by violation of all the norms, and where, in fact, it was a composite work, my lord, amounting to around 24 crores, man. But the way they have issued NIT, my lord, in piecemeal manner, to accommodate persons of their choice, my lord. I could not participate, my lord, because I am a class 1 contractor, man. My lord, so first of all, my lord would say, because of the operation of the Arunachal Pradesh District-Based Entrepreneurship Act, my lord, 2015, my lord, I cannot participate, man, in the NIT issued by the Executive Engineer Roing, man. So if your lordship would come to page 24, my lord. This is the Act of 2015. This is the Act, my lord. Then page 25, my lord, would come to the schedule, my lord. The table, if your lordship is chairman. This is the cost of works and eligibility of contractors, my lord. So, my lord, we are not bothered with 1, 2, and 3, my lord. 4. If your lordship would come to paragraph serial number 5, my lord. Above 3 crores and up to 8 crores, all registered contractors in class 2 categories domiciled within the territorial jurisdiction of assembly constituency. And then, my lord, 6, my lord, next, above 8 crores and up to 20 crores, all registered contractors in class 1 categories domiciled within the territorial jurisdiction of the district, and above 20 crores open to all eligible registered contractors in appropriate class, my lord. So basically, by this, my lord, a limit has been set, my lord. The pecuniary limit within which a class of contractor can participate, my lord. So 3 to 8.
Amount is only for 639.
Yes, my lord. In fact, my lord.
So you cannot participate in the said process.
Yes, my lord. Because, my lord, otherwise the sanction and the DPR, everything is for 24 crores, my lord. It would have been open to all, my lord. But what they have done is they have issued the NIT, my lord, in piecemeal manner in serial number 5, my lord, within 3 to 8 crores, my lord. So, my lord, if then my lord will come to Annexure 3, page 27, my lord. This is, I will try to show, my lord, how the work was prepared, my lord, the estimate and the sanction was done, my lord. Annexure 3, my lord. This is the detailed estimate for technical sanction. So and so. This is the same work, my lord. We'll see. Estimated cost is 2389.57 lakhs, my lord. 23 crores 89 lakhs 57 lakhs 57,000, my lord. Then page 28, my lord, is the estimate and design and scope, my lord. Everything, my lord. And 28, 29, my lord. 30 also, if you also would come to page 30, my lord, 30. This is the bridges, my lord. 3 bridges, my lord. One, if you will see bridge, steel composite bridge over so and so river. So and so subhead is steel composite bridge, approach road and river training work, my lord. If you will see, it's a similar, my lord, in every work, my lord. Along with the bridge, my lord knows, my lord, some river training, that is the abutment and bund that has to be prepared, man. That has to be constructed, man, to prevent the erosion of the, my lord, bridge, my lord. So this is a composite work, my lord. And accordingly, my lord, every details have been given, the mud work would be there, how much steel, so everything is there. And then finally, my lord, it was sanctioned on 12 September 2024, my lord, page 36, my lord. My lord is there, my lord, page 36. In exercise of the power delegated in clause so and so, read with so and so, duly amended from time to time, modified by so and so, technical sanction is hereby accorded for rupees 2389.57 lakhs for the work so and so, my lord. In the scheme and Arunachal Pradesh, inclusive of 1% labor cess and including the GST, my lord, administrative approval has been accorded for 2435 lakhs, my lord. 24 crores 35 lakhs, my lord. So this is a sanction for a composite work that is amounting 24 crores 35 lakhs, my lord. Now, my lord, the action of the authorities, my lord. If you also will see, my lord, page 37, my lord. Name of the work, it's the same, my lord. Estimated cost put to tender, my lord. 639.77 lakhs. 6 crore 39 lakhs, man. Even though the sanction is for 24 crores, man. 3 bridges, so and so, man. And one important thing, my lord, is time of completion, 24 months, man. 2 years time, man. It was there, man. And surprisingly, now even the authorities, my lord, they have even done away with the experience, my lord, required for the execution of work of a similar nature, my lord. That is at page 45, my lord.
Yes.
Page 45, my lord. This is the so and so, my lord. Then work, that is 639.77 lakhs. Time of completion, 24 months. And if you'll also will come to paragraph 2, my lord, serial number 2, my lord. What's the eligibility, my lord? Eligibility, my lord, serial number 1. They have struck off, my lord. That eligibility criteria has also been done away with. So accordingly, my lord, I submitted a representation, my lord. Since, my lord, through my representative, my lord, I submitted, my lord. Since it's for the class 2, I cannot participate. I do not even know who the tenderer is, my lord. So at page 52, my lord, Annexure 6, I filed an RTI through my representative, my lord, at page 52, my lord. I filed an RTI seeking the details, my lord, the bidding documents, the number of the participants, technical section, everything, my lord. Till that, it has not been furnished, my lord. That RTI information. However, on 18 November, I submitted a representation to the executive engineer, my lord, pointing out the things, my lord, which were illegal, my lord, in the NIT, my lord. So I burden your lordship, my lord, and take yourself through the annexes, my lord, few of the orders and the SOPs, my lord. My lord knows, my lord, CPWD manual, my lord, it is followed in the state of Arunachal, my lord. Now, to that effect also, my lord, the Principal Secretary has also issued an order, my lord, on 7/7/2023, my lord, at page 55, my lord. Type copy is at page 56, my lord. Office member to have a uniform tendering procedure in the state of Arunachal Pradesh and to exempt the APPWD registered contractors from submitting eligibility documents like similar nature of work, experience, tools and plans and technical stuffs at par with CPWD Works Manual 2020 and Standard Operating Procedure for CPWD Works Manual 2000. All the engineering departments under the state of Arunachal Pradesh who are involved in execution of civil construction works are directed to implement and comply with the provisions outlined in sorry, my lord, this should be SOP, my lord. SOP number 4/8 and 4/9 of the Standard Operating Procedure for CPWD Works Manual 2022 while inviting tenders and refer Annexure 21, my lord. CPWD Form 6 for e-tendering of SOP for CPWD Works and so, my lord. So basically what was said that regarding the eligibility and documents for similar nature was that SOP 4/8 and 4/9 should be followed, my lord. So on the next page, my lord, is the I've annexed the relevant portion, my lord, of the CPW manual, my lord. SOP number 4/8, my lord, down below. There is nothing, my lord, to show that, my lord, class 2 contractors should be exempted from the submission of the documents, my lord. Eligibility criteria, my lord. It should be exempted. That there is nothing, my lord. And in fact, my lord, if your lordship would come to page 60, my lord. Page 60, my lord, serial number 2, how the composite works are to be done, my lord. My lord has seen the technical sanction, the DPR. It's a composite work. A bridge cannot be constructed with the approach road, with the bund, my lord, river turning works. It cannot be done, my lord. So when it is a composite work, my lord, if you also will see, my lord, 2/4, my lord, Roman 4, my lord, at page 60, my lord. Composite works.
60.
60, my lord.
Yes.
Serial number 2, close, Roman 4, my lord. Entire work under the scope of composite tender is executed under one tender, one agreement, man. So it should be basically one tender and one agreement for an composite work. Similar is the, my lord, requirement in the SOP 4/9, my lord. 4.9, my lord, the CPWD that 6, the annexer 21 that referred to, that also says that composite works should be under one agreement, my lord. 4.9, my lord, at page 63 also, my lord, it is there, my lord. And CPWD form 21 also, my lord. Annexer 21, my lord. Everything, my lord, it says, my lord. There is no scope of doing away with the requirement of the execution of similar works by the class 2 contractors, my lord. And it says, clearly says, that composite works should be executed in one agreement, my lord. And there it has also been further said, my lord, that CVC guidelines should also be followed, my lord. So I will take your lordship just to now, so the CVC guidelines at page 77, my lord.
77.
77, my lord. Office memorandum, my lord. I will just read two paragraphs, my lord. The commission has received complaints regarding this discriminatory pre-qualification criteria incorporated in the tender documents by various departments, organizations. It has also been observed during intensive examination of various works contracts by CTCEO that the pre-qualification criteria are either not clearly specified or made very stringent / very lax to restrict, facilitate the entry of bidders. Number 2, my lord, the pre-qualification criteria is a yardstick to allow or disallow the firms to participate in the bids. A vaguely defined pre-qualification criteria results in stalling the process of finalizing the contract or award of the work in a non-transparent manner. It has been noticed that organizers at times pick up the pre-qualification criteria from similar work executed in the past without appropriately amending the different parameters according to the requirements of the present. Very often it is seen that only contractors known to the officials of the organization and to the architects placed on the select list. This system gives considerable scope for malpractice, favoritism, and corruption. It is therefore necessary to fix in advance the minimum qualification, experience, and number of similar works of a minimum magnitude satisfactorily executed in terms of quality and period of execution. That is, my lord, what is the requirement of the pre-qualification, my lord. Now, subsequent thereto, my lord, because otherwise the CPWD manual, my lord, it doesn't say so. The SOP 8 and 9, my lord, 4.8 and 4.9. It doesn't say anything about exempting, my lord, the class 2 contractors from giving documents for similar nature of works executed, my lord. And in fact, it says that composite works should be under one agreement, my lord. So situated thus, my lord, in fact, a legal notice was also served, my lord, to which they replied at page 80, my lord. My lord will see, my lord, how the executive engineer is contradicting himself, my lord, in this letter, my lord. To so and so, my lord. Reply notice seeking cancellation of so and so, my lord. Sir, with reference to the notice mentioned above, the work so and so, my lord, so and so, under Setu Bandhan work was sanctioned for rupees 24 crores 35 lakhs by the government of Arunachal Pradesh. Accordingly, technical sanction amounting to rupees 23 crores 89 lakhs 57,000 has been accorded. With regards to your legal notice, the following points may kindly be noted and treated as clarifications. The project was sanctioned on 23/10/2023 by MORT with a project period of 2 years. Since then, a year has passed to get the design vetted by the competent technical institute. With a target period of remaining only 1 year, it is prudent to expedite the project on ground immediately. Pausing here, my lord. My lord has seen the NIT, my lord. The project completion period is for 2 years, my lord. Now the executive engineer is making a false statement in the reply, my lord, given to the council, my lord, of the petitioner, my lord. Where is the time period for the NIT, my lord? That's why I had shown your lordship that it's 24 months, man. 2 years, man. Whereas he says in this only 1 year is there. So we are doing this in urgency, my lord. Then, my lord will see, keeping in mind the limited working season and the flood prone nature of the project location, which shall affect project execution, and project is to be grounded within the current working season. Then, my lord, 4, my lord will see, my lord. Serial number 4. The work scope of work is for 3 numbers bridges so and so approach road and guide fund, it should be burned, my lord. The tender of the approach on road and guide bund separate tender shall be subsequently float in due course of time after ascertaining the correct quantity required on completion of the abutments. Here, on the one hand, is saying we are doing this in urgency. This is a working season, flood prone area. Now, in the next paragraph, he says, will issue tender for the abutment and the bund, my lord. The guide bund is a necessary component for a bridge, my lord. It diverts, my lord, trains how the river is to be river flows, my lord. So now he says it is a flood prone area. This is a working season, but we will tender this, put this to tender some other time after taking into account the necessary calculation, my lord. Whereas, my lord, in the estimate itself, my lord, everything is there, my lord. Based on the estimates that sanction has been given, my lord. And subsequently, of course, he has said, my lord, the tender has been finalized and work awarded to the lowest bidder who has also started the work. Hence, the request for retender cannot be considered under this. My lord, here is the I made a categorical statement. This statement is also false, man. Everything, the reply given, man. Firstly, he says 1 year, whereas in the tender itself, it says 2 years. Now he says it's urgent, but now he says no flood prone area, but he will not issue tender for the bund, embankment also, abandonment. And this statement is also false, my lord. Categorical, we have made a statement. No work has started, my lord. We cannot make the parties, my lord. Because we do not know, my lord. We have sought for reply, my lord, from the RTI, my lord. But till that, we have not been furnished any reply, my lord. The manner in which this has been done. So now, subsequently, even only 1/4 of the tender sanction amount has been put to tender, my lord. Now, again, my lord, after some time, they will again do that, my lord. I will never be allowed to participate, my lord. They will put up to 8 crores, 3 times, my lord. Whereas it's a composite work, it should be as per the SOP, my lord, which the Principal Secretary PWD has said. Follow that SOP, my lord. SOP says composite work should be under one agreement. Secretly, that is my case, my lord.
Mr. Tapin, you were appearing for the rest of.
Lordship. Lordship, matter may be taken up on Monday, Lordship. I'll bring instruction why this thing had happened, Lordship.
Monday.
Lordship.
My lord, from 9 to, my lord, I have some personal difficulty, my lord.
Then
So,
10, Tuesday?
9 onwards, my lord, in that coming week, my lord. Then it will be 16 or 17, my lord, then otherwise.
17.
16 or 17?
No issue, any day.
Heard Mr. Desoki, Lord Council Petitioner, and also heard Mr. Tapin, Lord Senior Government Advocate, for us at this moment. Mr. Tapin submits that he may be granted some time to obtain necessary instruction. Here is accordingly allowed. Rest is the matter of 16.
17?
17, no issue.
17.
17.
My lord, may pray, my lord, till then, status quo may be maintained, my lord. Status quo. If they've already started, it's okay, but my
Yeah, Lordship.
categorical statement is that
Lordship, it pays 80, Lordship. Already a statement is there, Lordship, work has been awarded and work has started. Lordship.
that's why, my lord, I have a
So
categorical.
without
What
even,
your lordship
even
will
the
see, my
person
lord.
who has been awarded, he has not been implemented as
Not
party.
made a party.
Lordship.
I do not know, my lord, because I have been seeking information. They are not furnishing, my lord. Still 17, my lord, only let status quo be there, my lord.
No. Let him obtain instruction thereafter.
Then, unless then it can be considered.
Interfere the petitioner will be considered.
All right. Please, my lord. My lord, this is also another tender matter, my lord. Here, my lord, the issue that this honorable court has to decide. Because here, my lord, the facts, my lord, here is that the firm, my lord, the private respondent number 6, my lord, it was earlier a proprietorship firm, my lord, and the proprietor was the respondent number 7, my lord, private respondent number 7, my lord. Now, during this simultaneous election that was held in the state, my lord, in the March and April, my lord, 2024, my lord, the respondent number 7, who was the earlier proprietor of measures YP Enterprise, my lord. He, with the intent to contest the elections, my lord. Somehow, I don't know how we do not have the recourse also. He transferred, my lord, the proprietorship, my lord, to the respondent number 6, man. Now the respondent number 7 is a sitting MLA, my lord. He won the elections, and the issue, the limited issue, whether, my lord, the proprietor, when the proprietorship form is changed, my lord, whether the subsequent proprietor will have the, my lord, experience, and he can take benefit of the experience of the earlier proprietor, man. Because proprietorship form, my lord, knows, my lord, it is not a legal entitlement. It is only a business carried out by the proprietor, man. Unlike companies registered under Companies Act, my lord, they have perpetual succession and it's a legal entity by itself. But when we talk about the proprietorship firm, my lord, when the proprietor is gone, my lord, every experience of the proprietor, my lord, is also gone, man. That is to my understanding, my lord. So, my lord, here, my lord, NIT, my lord, is at page 22, my lord.
Yes.
Page 22, my lord. This is for construction of the name of work, so and so, my lord.
Was allotted to respondent number 6.
6, my lord.
And respondent number 6 is not yeah, you don't have the requisite qualification.
That is my submission, my lord. Because the proprietorship was changed in 2024, man. I will show your lordship, man.
Name of the firm remains same.
Form remains same. The proprietor has changed, man. Strange situation, my lord. So I will try to satisfy your lordship, my lord. What is a proprietorship firm and how it is linked to an individual. I'll try to satisfy your lordship. So, my lord, this is the work, my lord. Construction of KGBB type 3 at Keith, so and so, my lord.
So first you come to the point then.
My lord.
First you come to the point. This proprietorship firm.
It's proprietorship firm, my lord. That, of course, my lord. Then proprietorship, my lord, if your lordship would come to page 213, my lord. My lord, before that, my lord, sorry, my lord, I'm sorry, my lord. If your lordship would come to page 183, my lord.
What?
83. One 183 is the, my lord, 183 onwards, my lord, is the list of the enlisted contractors. Lordship is there, my lord. Annexure 5 series, man.
Serial number?
Yes, my lord. This is, my lord, if you lordship, this is valid registered, validated contractors firms under PWD Arunachal Pradesh, my lord. Top, my lord, will see, my lord. PWD class 2 civil category S on 31/3/2023, man. This is the earlier one, man. So if your lordship would come to serial number 67, my lord, at page 192, man.
190?
192, my lord. At serial number 67, my lord. YP Enterprise, my lord. Sri Oni Panyang, my lord. Son of Lloyd so and so, my lord. Village so and so, my lord. My lord will see the enlistment number and date, my lord. Enlistment number and date, number C so and so CASU W 2019-22 152 dated 10 February 2021. 10 February 2021. This was enlisted in the name of the proprietor Sri Oni Panyang. Now, my lord, will see the next page, my lord. This is the list of valid and listed revalidated contractors firms under PWD Arunachal Pradesh Class 2, my lord. Next page, my lord. As on 30/8/2024, my lord. Now the proprietorship has changed, my lord. And if your lordship would come to page 201, my lord, it's serial number 62, my lord. 62, my lord. Measures YP Enterprise, my lord. Kalan Partin. So he is the respond number 6 now, my lord. And if you also will see enlistment number at that, my lord, it's the same number, my lord. Otherwise, this is not disputed, my lord. And that is also clear at page 213, my lord. We do not know, my lord, how it has been changed, my lord. So we have made the PWD Chief Engineer CSQ as a party also, my lord. Only to the extent of knowing how that was done, my lord. Page 213 is the office order, my lord. Subject corrigendum, my lord. Provisions of Arunachal Pradesh enlistment of contractors in work department rules 2008. The proprietor of the firm measures YP Enterprises, village Tebo so and so, district so and so, which is enlisted in class 2 BNR under civil category wide registration. Your lordship is a registration, my lord, issued by number so and so dated 10/2/2021 is hereby changed as given below, my lord. Registration number is the same, my lord. Address of the firm, my lord. Earlier it was this, my lord. YP Enterprise Village so and so. All name of proprietor and postal address Oni Panyang, my lord. Now the new name of proprietor and postal address. And this was done on down below. You also would see, my lord, 22nd March 2024, my lord. So basically, this new proprietorship form was born only on 22nd March 2024, man. Without that, before that, man, the proprietor was this different person, man. So basically, although the name may be same, man, the proprietorship has, when it's changed, man, it's a new, man, birth only, man, for the form, man, under the respond number 6, man. This is how it was changed, man. Now, if your lordship just take your lords to some tender conditions, my lord, how saying that he's not eligible, my lord.
Mere changing of the proprietorship will have any effect upon the past experience of the firm?
That is basically my case. That is my basically. I will try to show your lordship, my lord.
Yes, Mr. Ratan?
My lord, yes, my lord. My lord has put up the right query, my lord. My lord, proprietorship firm, proprietor has changed, my lord. It has been given to the different person or another person, but the firm remains, my lord. It's a separate entity, my lord. Firm has its own assets, its own manpower, own machineries, equipments, managers, technical persons. The work so executed by a firm, the experience will always remain with the firm. That is the it will automatically not just by the change of proprietorship. The experience will remain with the proprietor and not with the firm. In instances, even power of attorneys are given to execute the work, but the experience is of the firm, not of that power of attorney. So firm will retain its own experience, to my understanding, my lord, to respect of, because it's a separate entity, my lord. Proprietorship may change. And one proprietor may sell his entire firm, gift it to some other person, but the firm remains a separate entity.
Oh, my lord.
This would be an interesting.
I beg to differ, my lord. That, my lord, proprietorship firm doesn't have any legal entity, doesn't have any separate legal entity, my lord, without the proprietor, my lord. I will place judgments, my lord, before your lord. My lord, as per the submission of the learned additional AG, my lord, Supposing, my lord, I have a car and I have a driving experience of 15 years, my lord. I give my car to the learned additional agent. Can I give my experience also? He might own the car, but he'll not have my experience, my lord. Otherwise, I have judgments, my lord, which say, my lord, it doesn't have a separate legal entity without the proprietor, my lord. That is what I am trying to demonstrate. My lord.
For the
So-
documents,
Yes, no, my lord, but there are certain documents also which I would like to show, my lord. If your lordship would come to page 216, my lord. 216, my lord.
yes.
Because as per the eligibility, my lord, the contractor has to show their and last 3 annual turnover also, my lord. There is a requirement. Now, this is the registration certificate, my lord. Legal name, Kalin Parkin, my lord. And down below, my lord, period of validity, my lord, 19/8/2024, my lord. This new firm, my lord, YP Enterprise, my lord, is GIC. Under the new proprietorship, it was registered only on 19th of August 2024, my lord. So he cannot have last 3 years experience, my lord. Then, my lord, 219, my lord, page 19, my lord. He has to show the turnover for the last 3 years, my lord. 219 is the GST returns, my lord. Since it was incorporated only in the March, GST registration was done only in the month of August, my lord. This return is from year 2024-25, my lord. You'll see August, my lord, top, my lord. The lordship will see top right hand, my lord. 0, 0, 0, 0. Everything is 0, my lord. Next page, 0, my lord. GST returns, my lord. Nothing, my lord. 0, my lord. Then, if your lordship will come to 222, my lord, page number 222, my lord.
Yes.
This is the provident fund confirmation, my lord. This was in the month of July, my lord, 2024, my lord. This is now the new proprietor, my lord. Now, if the lordship will come to page 224, my lord. Payment confirmation received, my lord. 30 September, so and so, my lord. Total members, my lord, nothing. Till date, my lord, he has not paid anything for employees, my lord. 0, my lord. Everything is 0, my lord. And if your lordship will come to page 226, my lord. Because that firm, my lord, has to have a turnover, my lord, certain amount, my lord, that is prescribed in the NIT, my lord. 226, my lord, is the ITR, my lord. ITR, if your lordship, the current financial year, if 0, if any, 0, no income, total income 0, profit 0, adjusted total income 0, net tax payable 0, down below, my lord, tax payable, refundable, my lord, tax and interest paid 0, my lord. This documents, my lord, this is for the new proprietor, my lord. My income, the income of the earlier proprietor, how cannot I take benefit of that, my lord? Income tax, my lord, and everything, my lord. It has to be for the proprietor, my lord. It's a person, my lord. Your lordship has seen it. Everything is 0, my lord. Then how does this experience come from, my lord? That is my lord, basically. These documents, the financial statement, my lord. Your lordship has seen. GST registered in August 2024, my lord. Employees still that employees provident fund, no payment has been made. Income tax returns 0. Everything is 0, my lord. So, my lord, regarding that, my lord, that proprietorship and I'll just, of course, these were in context to different issues, my lord, but how the proprietorship has been defined, my lord, that I will. First, my lord, Raghu Lakshman Narayan, 2007, my lord. This was, of course, issue different issue was there, my lord, that under the NIA, my lord, whether the employees of a proprietorship firm would be liable, my lord. That was the issue, my lord, in this case, my lord. Because check regarding check bounce was there, my lord. So if your lordship would come to paragraph 9, my lord, at page 105.
Yes.
The description of the accused in the complaint petition is absolutely vague. A juristic person, my lord, from here on, a juristic person can be a company within the meaning of the provisions of the Companies Act 1956, or a partnership within the meaning of the provisions of the Partnership Act 1932, or an association of persons which ordinarily would mean a body of persons which is not incorporated under any statute. This is of importance, ma'am. A proprietary concern, however, stands absolutely on a different footing. A person may carry on business in the name of a business concern, but he, being proprietor thereof, he would be solely responsible for conduct of its affair. A proprietary concern is not a company. Company, in terms of the explanation appended to section 141 and so means anybody corporate and includes a form of other association. Director has been defined to mean in relation to a firm, a partner in others, whereas in relation to a company incorporated and registered under Companies Act 1956 or any statute, a person as a director must come within the so and so manner. So basically here, what has been said, my lord, the companies, my lord, under the Companies Act, my lord, they have a legal entity, but a proprietary concern, my lord, it stands on different footing, my lord. And relying on this, my lord, this latest judgment that I could find, my lord. This is by Vinayak Purushottam Dubey, my lord, which 2024 volume 9, my lord. Two judgments, my lord, by Justice Nagaratna and Justice Ujjwal Bhuya, my lord. If your lordship will come to paragraph 22, my lord, at page 407, my lord. Here, the issue was regarding the court order and decree to be implemented on the legal heir, my lord, of proprietorship firm, my lord. But we are not concerned, we'll just confine to the proprietorship, my lord. Paragraph 20. In this regard, it is necessary to discuss the jurisprudential status of a proprietary concern. In report of the Insolvency Law Committee submitted in February 2020, the definition of proprietorship firms read as under. Definition of proprietorship firms. Proprietorship firms are businesses that are owned, managed, and controlled by one person. They are the most common form of business in India and are based in unlimited liability of the owner. Legally, a proprietorship is not a separate legal entity, my lord, and are usually not a separate legal entity and is merely the name under which a proprietor carries on business. The 2000 judgment has been referred to, my lord. Due to this, proprietorships are usually not defined in statutes. Though some statutes define proprietorship, such definition is limited to the context of the statute. For example, Section 2 HAA of the Chartered Accountants Act 1949 defines a sole proprietorship as an individual who engages himself in practice of accountancy or so and so on. Notably, proprietorship firms have also not been so and so. But this is what has been said, my lord, regarding legally, a proprietorship is not a separate legal entity and is merely a name under which a proprietor carries on business. And then, my lord, if your lordship would come to page 33, my lord, at page 410. While relying on the 2007 judgment, my lord, 33, in so and so, while distinguishing a juristic person such as a company, a partnership, or an association of partners, or an association of persons from a proprietary concern, it was observed that when a person carries a business in the name of business concern, but he being a proprietor thereof would be solely responsible for conduct of its affairs. A proprietary concern is not a company. Further, a proprietary concern is only the business name in which the proprietor of the business carries on the business. That is what the legal method understanding of a proprietorship firm is. And just one more line, my lord. Paragraph 36, my lord. Of course, it was regarding the paragraph 36, my lord. Down below, last, my lord. In other words, my lord. Down below, my lord. Last 3 lines, my lord, from the bottom. Paragraph 36, my lord. In other words, my
In
lord.
other
Yes.
words, yes.
In other words, where a decree or order is not against the estate of a deceased sole proprietor, but based on skill and expertise of the sole proprietor, we of the view that in the latter case, the obligations which a sole proprietor would come to an end on his device, and same cannot be imposed on his legal heirs and representatives. Basically, madam, what has been said, my lord, is that expertise, my lord, my skills and expertise, it cannot be passed on, my lord. Thus, that is why I'm saying, my lord, that proprietorship firm doesn't have a separate legal entity when the proprietor is gone, my lord. And when, in this case, when the proprietor is gone, my lord, new proprietor has come in, it has to be his experience, his turnover, my lord. And I have shown, my lord, your lordship, everything is zero, my lord. Everything is zero, my lord. Then how did he qualify, my lord? That is my case, my lord. Well, this is an issue, my lord, of course, which needs to be decided. Legal issue is there, my lord. So, but this stage, my lord, I'll pray, my lord, let notice go, my lord, and my lord, let the private respondent not proceed with the status quo will be maintained, my lord. This is an issue, my lord, which needs to be decided, my lord, by this court, my lord.
My lord,
Otherwise, I've shown, my lord, how everything, financial turnover zero, GST return, oh, everything is zero, my lord. There is no ITR zero. How can such person be awarded work, my lord? It is, he is not eligible as per the terms of the contract, my lord, tender, my lord. That is my submission.
page 182, my lord, of the writ petition, my lord, his financial bid of the petitioner has been rejected being inconsistent, my lord. First of all,
Oh, sorry
182.
to interrupt, my lord. That is one more issue, my lord. Of course, I was trying to show your lordship, my lord. Because the eligibility, my lord, the terms and conditions, it permits for 5% variation, my lord. Variation of 5%, my lord. Now, if your lordship will come to page 182, my lord.
Yes, and except for.
And except for 182, my lord. Mine is serial number 2, my lord. Serial number 1 is minus 10%. It is, of course, obviously without, not within the variation, my lord, gone, my lord. Because as per the conditions, it permits only up to 5%, my lord. My bid, my lord, it is exactly minus 5%. Down below that, private respondent number 6 also minus 5%, my lord. But nothing, my lord, it only says inconsistent, my lord. Nothing, no explanation how it is inconsistent. I am within the permissible limit, my lord. This 5% variation is permitted in the condition itself. But otherwise also, if I am not, if my bid is inconsistent, even the YP enterprise, it cannot be awarded. So there should be a fresh tender, my lord. Let there be a fresh tender then, my lord. But the work cannot be awarded to this private respondent.
My lord has seen page 182.
Yes.
The 182. The petitioner's bid, my lord, financial bid has been rejected. Of course, both has quoted -5%, my lord. But if column number 7 is same, items, number of items of rate within minus plus and -5, petitioner is 71 and the private respondent is 108. Then column number 8, number of item rates beyond plus and -5 is petitioner is 41 in 41 items. In And for the respondent, private respondent, it's 4 only. Now, details have been given, my lord. So the petitioner's bid has been found, mostly found in items to be more items to be beyond the permissible rate, my lord. Be that as it may, my lord. What now, my lord? My lord, in Tata Cellular, Tata Motors, my lord, it's a legal point he has made out whether the firm's experience will continue with the firm or will remain with the proprietor. My lord, in para 53, my lord, I'll just read, my lord.
Yes.
Para 53, from the fourth line, from the fourth line, my lord, it was further held that the states in corporations, instrumentalities, and agencies have the public duty to be fair to all concerned. Even when some defect is found in the decision-making process, the court must exercise its discretion powers under Article 226 with great caution and should exercise it only in furtherance of public interest and not merely on making out of a legal point, my lord. The court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. Only when it comes to the conclusion that overwhelming public interest requires interference, the court should interfere. He has made out a legal point that has to be decided whether that experience will remain with the proprietor or the firm. Now, there are 54 also. As observed by this honorable court in so and so, reported in so and so, that while invoking power of judicial review in matters as to tenders or awards of contract, certain special features should be borne in mind that the evaluation of tenders and awarding of contracts are essentially commercial functions, and principle of equality and natural justice stay at a distance in such matters. If decision relating to award of a contract is bona fide and is in public interest, courts will not interfere by exercising power of judicial review, even if a procedural aberration or error in assessment and prejudice to a tenderer is made out. Power of judicial review will not be invoked to protect private interests at the cost of public interest, or to decide contractual disputes. Here, my lord, private respondents have already been awarded. Now, his financial bid has been rejected. Only the issue has to be determined by this court. A legal issue has been agitated before this honorable court. That will decide whether the experience of a firm will remain with the firm or with the proprietor. That is a matter to be decided. So only notice may be issued. The work may not be stopped in the public interest. It's a school building.
Sir, we'll pass the order.
Well, just,
Implement this issue.
I'll just give a short,
Experience of the proprietor.
short reply, my lord.
Yes.
Just, my lord, public interest, my lord. Whether it lies in the construction of a project by an inexperienced person, that is another issue, my lord. Otherwise, I was under the impression that my the learned additional AG will put press that the judgment of NG projects, my lord. This is subsequent to the NG projects, my lord. Here also, my lord, because NG projects said, my lord, that read court should not interfere. My lord. Now, relying on these NG projects, my lord, the High Court of Bombay, my lord, dismissed their writ petition, even though, my lord, the acceptance of the bid of the respondent, private respondent was.
Subsequently, that decision was clarified.
Yes, my lord, this, of course, this is at page 3, my lord, if lordship will see, my lord. We have heard the learned counsel for the appellant. We find that the High Court was has totally misread the judgment of this court. Respondent number 4 was declared eligible in a flagrant violation of principles of natural justice and all fairness in the process of determining the eligibility of tenderers. The bid of respondent number 4 was accepted when at the time of opening of the technical, the said respondent was disqualified. Ma'am. Therefore, the manner in which the bid was accepted shows arbitrary exercise of power, and accordingly, it was interfered, madam, by the Honorable Supreme Court, madam. Where your lordship has seen, it's not just a legal issue, madam. It is based on the facts also, madam. I've showed your lordship, madam. Zero, everything is zero, madam. This new firm, madam. The new proprietor, your lordship has seen, madam. Everything is zero, madam. Whether such a person constructing a public project would be in the interest of the public, madam. Fortunately, madam, my experience, I was also on that side for a quite some time, madam, 6-7 years. I was also there representing the government, madam. I know how these actions are done, my lord. There are instances, my lord. Here is such a case, my lord. Even though this value nothing, no, even after going through the document, everything is zero, my lord, no experience. Even then they are going to award the work. Even if page 82, the learned additional AGS referred to, my lord. There also, my lord, the bid of the respondent number 6 has also been shown where it is not balanced, my lord. If mine is inconsistent and the private respondent 6 is not eligible, there will be a retender, my lord. This is a public largesse, my lord. It cannot be awarded to a person of their choice, my lord. And the private respondent number 7, the earlier proprietor is now an MLA, sitting MLA, my lord. He gifted it to someone. That person is now being awarded even without any experience. This shows how the work has been awarded, my lord. Everything. My lord will just protect, my lord, for a short period, my lord. Let there be status quo, my lord. If this is allowed, my lord, illegality, my lord, it will perpetuate, my lord. It's a case of my fundamental right also, my lord. Right to carry on my profession, my lord. It cannot be curtailed like this, my lord. They cannot just give it to anyone of their choice and later come to the court saying that no, the work has been awarded. Work has not yet started, but it was the declaration was only made on November 23, my lord. So work has not yet started, my lord. Let some protection be there, my lord.
Yes.
My lord, my respectful submission, my lord. In such, my lord, contract matter, my lord, especially in tender, my lord, there's a two-phase, my lord. Two-phase. First phase is of post-contract. And the first phase is pre-contract and subsequent is post-contract, my lord. In case of pre-contract, my lord, this public law remedies lies, man. That is the exercise of power under 226, my lord. In that case, certain, my lord, certain extent, my lord, if there's against the public interest, avoiding the public interest, my lord may exercise the jurisdiction as a 226, my lord. But when it is crossed that stage, man, now it's become a contract. It's the realm of the contract. Now that comes under private law remedies now. In case of pre-contract stage, my lord, it's a public law remedy where my lord will exercise the power under section 226, my lord. That is why, my lord, the Jagdish Mandal case, my lord, the guideline has been laid down. The utmost all the point, vital point is whether the public interest is prejudiced or not. If it's not, then it's not a case for interference, even in the case of pre-contract stage, that is while exercising the public law remedies. Now, in this case, where since the work has already been awarded, now it is a case of post-contract stage now. Now, post-contract stage, now private law remedies lies, madam. In that case, madam, public, it's not a case of public order. The under 226, we cannot exercise, my lord. Even if there's illegalities, my lord, then it is the case, my lord, everything will be governed by the contract, my lord. Even if suppose the bidder the contractor is inexperienced, he cannot comply the term and condition, if he cannot contract, there's a provision to take care of all those provision, my lord. He can be terminated, blacklisted in this, everything, my lord.
Mr. Document, tell me how the contract can be awarded to a person who has zero experience?
My lord, that is why, my lord, because my lord, it is a registered contractor, my lord.
Maybe.
My lord, only in case of certain exceptional criminal cases only, if there's something, the lifting of corporate veil, it equally applies here, in my respectful submission, because it is a legal entity, because the proprietor is behind the scene, the property is for management purpose, but so far the establishment as a farm, it exists, irrespective of change of the partner, So in my respectful submission, even NG project, why this pre-contract and post-contract has been defined. In case of, say, if the work has been awarded, if still if court find that there's utterly illegal has been committed, arbitrary, in that case, the party should be relegated to the civil court for claiming and damages and all, breach of any damages because of the wrongful act, But it's not a case for the exercising the jurisdiction under 227. It's my respectful submission. Now, in this case, as per my instruction, the work has been awarded on 20 November, So in that case, what is the public interest demand is the expedition of the project, It's related to the school building, That is why the more important is the execution of the project, which is the public interest. In respectful submission, therefore, at this stage, the interim order, would be prejudice the public interest. We can examine, of course, there's whatever the step taken by.
I've already awarded the work.
It
remains to be examined now.
In that case, suppose illegalities have.
It cannot be, they will say,
It can be-
we have awarded the.
It can be subject to the outcome. If he succeed, in case he can claim for the compensation also, loss, anything, It's the provisions there, That is why,
That is,
public interest part, they have to say.
that is why, I had brought this order passing Jai Bholenath, because here it has been clearly said, the NG projects cannot be misread, There cannot be arbitrariness, And my brother here has said about the lifting the veil, I understand lifting the veil would show that the respondent number 7 has been awarded the work, it seems, which the MLA, I'll pray for, some protection, Otherwise, it will merely be an academic exercise.
The NIT? Page number?
Well, one thing to clarify, the respondent number 7, who is the MLA, is from a different constituency, and this the person to whom it has been transferred, it's from a different constituency.
But he's
And the
still,
work is
he's still the MLA, He's
no,
still
that
MLA,
is a different constituency,
Adjoining
different place.
constituency, my lord.
Totally different.
Adjoining
It is not
constituency.
possible for conducting business in another constituency by.
No, my lord, the subsequent proprietor
NIT,
he
my lord,
is
is page 24,
from a
20,
different
22, my lord.
Page?
NIT, 22, my lord. 22, my lord.
Where are the terms and conditions?
It is at serial number 16, my lord. It starts at serial number 16. At page 28, my lord. Serial number 16, my lord.
Yes.
16, the bidder who fulfills the following initial requirements shall be eligible to apply. A is the work so and so. Now there they have said that this has been exempted, my lord. So I will not bother your worship. Then next page 29, my lord. B, my lord. Turnover, my lord. At page 29. B, turnover, my lord. And average annual financial turnover on construction work should be at least 30% of the estimated cost put to tender during the immediate last 3 consecutive financial years. The value of annual turnover figure shall be brought to current value by so and so, my lord. So last 3 years, my lord, turnover should be given, my lord, to be eligible, my lord, to participate.
We'll see and pass the order.
My lord, all right.
Mr. Ratan, you want to say something?
No, my lord, just to clarify, the petitioner, that the proprietor, earlier proprietor, is an MLA of another constituency, and the subsequent proprietor is from another constituency, and the work has been awarded not to that MLA's constituency. It is to the present this
That
proprietor's
I- that-
constituency.
That I have mentioned that he is from another constituency. I mentioned in the
Because
petition also.
my lord may
Adjoining
seem
constituency.
that
my lord.
the MLA is from the same constituency, and in his constituency, the work has been awarded. It's not the case. Work is awarded in different constituency to the subsequent transfer.
It means that.
It is
it
not
cannot
connected with the MLA.
Influence the.
Yes, ma'am.
Yes.
It cannot influence. It's not connected with that MLA.
Well,
Okay.
your lordship knows the MLA, my lord, adjoining constituencies are there, my lord.
If it not please, your lordship, my lord, the petitioner is challenging the notification, page number 60, your lordship. Annexure 6. This is the impugn notification, your lordship.
Page number?
60,
Yes.
60.
Yes.
My lord, this notification, by way of this notification, your lordship, this notification was issued under Article 64, your lordship, and under Article 335, your lordship. By way of this notification, the state government has made 100% reservations in with regard to Group C and a multitasking post, your lordship. And this is not permissible, your lordship. This may I read the relevant portion, your lordship, of this notification, clause 1, your lordship. 100% post out of 80% stated above in Group C and
Page
multitask
number, page number?
60, 60.
Yes.
My lord, this notification has been issued under Article 16 for your lordship and Article 335 of the Constitution, your lordship. By way of this notification, 100% reservation has been made in Group C and multitasking post, your lordship, in all departments in the district offices as well as in district administrations against direct recruitment quota, your lordship. Which shall and this notification provides that the appointments shall be made amongst the APSC candidates of that particular concerned district, your lordship. And this notification is not permissible in as much that it violates Article 16 of the Constitution, your lordship. And that is why the petitioner is before your lordship challenging this
But
notification.
this power is exercised under
Article
clause
16,
4 of the Article 16.
yes, your lordship, and that is why the petitioner is before your lordship, because clause 16, clause 4 of 16, Article 16 does not provide empowers the state to make reservations on district on the basis of domicile, your lordship. May I take your lordship to Article 16 for in that case, your lordship?
Yes.
My lord, Article 16, equality of opportunity in matters of public employment. Clause 1, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Clause 2,
No citizen shall, on grounds only on religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment or office under the state. Nothing in this article, clause 3, Your Lordship, nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory, any requirement as to residence within the state or union territory prior to such employment or appointment. Clause 4, this is where, the notification has been issued under this clause, Your Lordship. Clause 4, nothing in this article shall prevent the state from making any provision for pose in favor of any backward class or citizens in which, in the opinion of the state, is not adequately represented in the services under the state, Your Lordship. My Lord, article empowers the Parliament, Your Lordship, to frame rules regarding, it is only under clause 3 of the 16, Your Lordship, Article 16, that the Parliament is empowered to make rules, Your Lordship, and not the state. And however, in this case, Your Lordship, the state government, by an action of an executive fiat, Your Lordship, has framed this notification, which is not permissible. And this article specifically bars the state government to make reservations in case of appointments, Your Lordship, with regard to a domicile of a state, Your Lordship, of a district. And my Lord, the Honorable Supreme Court has also held in several cases, Your Lordship, that the state cannot make reservations on appointments for the purpose of offering employment to the concerned persons of a particular district, Your Lordship, on the basis of their domicile or residence, or by their place of birth, Your Lordship. And this is, and the state government, however, has invoked this particular clause, Your Lordship, and this is not permissible.
Notice may be issued for today, Malak, because I believe there is no interim order. Notice may be issued.
But similar notifications are available in other states also.
I beg your pardon, Your Lordship.
Similar kind of provisions are made in some other states also.
My Lord,
Reservation for the candidates of the particular district.
my Lord, the Honorable Supreme Court has held that such kind of reservations on the basis of district, Your Lordship, be it a region or any lower district, region of a particular.
Any authority,
Yes, Your Lordship.
can you show?
2002, volume 6. (562), Your Lordship.
Paragraph number?
Paragraph number 13, 14, 15, and 16, Your Lordship. 562.
Paragraph number
13, Your Lordship.
13.
13. My Lord, the Honorable Supreme Court has also held that when a reservation is made between a class of persons, Your Lordship, citizens, that reservation would be based on social and educational backwardness, Your Lordship, and not on religion, caste, creed, or place of birth, Your Lordship, place of birth, Your Lordship. I'm sorry. Paragraph 13. May I read, Your Lordship? Before proceeding further, we should steer clear of a misconception that surfaced in the course of arguments advanced on behalf of the state and some of the parties. Based on the decisions which countenance geographical clarification for certain weighty reasons such as socio-economic backwardness of this area for the purpose of admissions to professional colleges, it has been suggested that residents within a district or rural areas of the district could be a valid basis for classification for the purpose of public employment as well. We have no doubt that such a sweeping argument, which has the overtones of parochialism, is liable to be rejected on the plain terms of Article 16.2 and in the light of Article 16.3. An argument of this nature flies in the face of the preemptory language of Article 16.2 and runs counter to our constitutional ethos founded on unity and integrity of the nation. Attempts to prefer candidates of a local area in the state were nipped in the bud by this court since long past. We would like to reiterate that residence by itself, be it within a state, region, district, or lesser area within a region, cannot be a ground to accord preferential treatment or reservation, save as provided in Article 16.3. It is not possible to compartmentalize the state into districts with a view to offer employment to the residents of the district on a preferential basis. At this juncture, it is appropriate to undertake brief analysis of Article 16. Article 16 has been
Article, this clause 4 has not been discussed in this.
My lord,
Clause 4.
it has been, my lord, may come to next paragraph. My lord, if your lordship takes clause 4 of Article 16, your lordship, the state can make reservations of appointments with regard to those class of citizens, your lordship, who are backward, your lordship, in the opinion of the state. And to determine the backwardness, your lordship, that backwardness would be on the basis of social and economic decisions, your lord, factors, your lordship, and not on the basis of a place of domicile, a birth, caste, creed, or gender, your lordship. And that backwardness has to be determined only on the basis of social and economic factors, your lordship. That is what the Honorable Supreme Court has held in this judgment, your lord.
Well, let notice go then. Discuss.
Yes, ma'am. I will appear for 1, 2, and 3.
Pardon is the Tamok, Learned Counsel for the Petitioner, and Mr. Andropan, Learned Counsel for the Learned Petitioner to the respondent number 1, 2, and 3.
Yes.
And Mr. Carto,
My lord, I am for respondent number 4.
respondent number 4. Legality and validity of the notification number AR47 struck 10 dated 2/6/2011 issued by the secretary, chief secretary to the government of Arunachal Pradesh is challenged in this petition under Article 226 of the Constitution of India. Peruse the petition and the documents flash on record, and also peruse the notification dated 2nd June 2011. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. It's the matter of 4 weeks.
Much obligation.
May it please, your lordship. Your lordship, this particular matter pertains to a transfer, your lordship. Actually, not transfer, but against the cancellation of transfer, the writ petitioner has preferred this particular writ petition, your lordship. Your lordship, the petitioner in this case is a ministerial staff, your lordship, and is presently serving as upper divisional clerk in the district of Changlang, your lordship. Your lordship, the normal rule which is prevalent in the state of Arunachal Pradesh is that the ministerial staffs of various departments are being appointed and controlled by the deputy commissioner in the district, your lordship. So, your lordship, all the appointments, transfer, and other consequential orders are of a incumbent is made by the deputy commissioner itself, your lordship. Now, your lordship, your lordship, may I bring you to page number 22 of my writ petition, your lordship.
So you've been transferred from which place to which place?
Your lordship, I have been transferred from, it's an office transfer, your lordship. Initially, I have been transferred to page, serial number 4, your lordship, in page 22, your lordship, Sri Wangdam Jamai.
Yes.
I have been transferred from DMO office to development branch, your lordship. It was done on 10th January 2024, your lordship. Now, next page, your lordship, that is page 23. Again, that transfer order was modified, and thereafter, your lordship, at serial number 2, I have been posted transferred to establishment branch, DC office, Changlang, your lordship. Now, next, your lordship, page number 24, your lordship. Again, on 2/7/2020, page number 24, your lordship. Again, on 2/7/2024, your lordship, I have again reshuffled, and I have been reshuffled from establishment branch to judicial branch of the DC office, Changlang, your lordship. Now, here, your lordship, up to this, I do not have any representation on my medical ground, your lordship. This is chronologically.
The DC office?
No, your lordship. I have been transferred to DMO office. That was later on cancelled, your lordship. I'm coming to that also, your lordship.
Now, in which office you were serving?
I have not joined, your lordship. Because, your lordship, my representation was at page 25, your lordship.
Now you were serving in which office?
Your lordship, I was serving in the DC office last time, your lordship.
DC office.
DC office, your lordship.
And in the DC office, this judicial branch has been assigned to you.
Has been assigned to you, assigned to me, your lordship.
Yes.
Then at page number 25, your lordship, I made a representation before the respondent number 2, stating that on my medical condition.
It is in the same establishment, DC office.
Yes, your lordship. In the same establishment, office transfer from DC office, I requested to be transferred to the DMO office, Changlang, your lordship. That was also granted to me, which is, your lordship, would find at annexer 20, page number 28, your lordship. This was my, on the health ground, your lordship, this page number 25 representation was given.
Both the offices are in the same,
in the same
headquarters,
station,
same place.
no dispute in that.
Yes.
It is in the same
Then-
state. Then I'm on the ground of, your lordship, having been overburdened by the works, and due to my ill health, your lordship, I was not able to cope up the work. So I made the representation before the appointing authority to let me shift it in the DMO where I can get less workload, your lordship. That was just my representation, and citing on the medical ground, it was made, and that was also granted to me, your lordship. Now, when I went to the DMO office, your lordship, for joining, your lordship, the DMO did not accept my joining report. Your lordship may see at page number 29, I have been released from DC office also, your lordship. On my representation, your lordship, DC has released me also. After getting that release order, on page number 30, I went for joining it to the DMO. Now, This is the page number 31 is the relevant portion, your lordship. Here the DMO has, your lordship, I may read, with reference to the subject cited above, I am to inform you that Sri W. Jomoy, that is me, your lordship, has transferred to DMO office Changlang, for which his joining report has not been accepted by the undersigned. Copy of original joining report forwarded to your good office. Thereafter, your lordship, after my joining report was not accepted, after receiving this letter, your lordship, page number 35, the DC has cancelled my initial transfer order, your lordship. Against that order, I approached before your lordship. Without assigning any reason, because at first, your lordship, I have the right. I understand your lordship, transfer is an incidence of service. What a government servant can do, he can just file a representation stating about his inconvenience. That representation has been considered. And as soon as it has been considered and my transfer has been approved, your lordship, I have a legitimate expectation to be joined in the place where I have been posted. Now, your lordship, the district medical officer has not accepted my joining report without having any. District medical officer has acted ultra vires, your lordship, because district medical officer does not have any say over the transfer, appointment, or any consequential, your lordship, action which may be taken to the ministerial staff. Ministerial staffs are being regulated by the district deputy commissioner only. So once the appointing authority has transferred me to DMO office, the DMO could not, your lordship, refuse to accept my joining report, your lordship. Now the thing is that when this particular, your lordship, non-acceptance of joining report letter was sent to the DC without assigning any reason, your lordship. Without assigning any reason, your lordship, DC has cancelled my transfer order. Thereby, your lordship, it eventually resulted the violation of my legitimate expectation. Thing is that, your lordship, my humble submission is that prejudice may not occasion only when transfer is done at different place, your lordship, where I have been suffering from tuberculosis. I'm not able to, I'm at the fag end of my retirement. I'm not able to cope up the workload in the DC office. That's why I made the representation. Once it is accepted, your lordship, once it is approved, DMO ought to.
Is there so much workload in the judicial department of the DC office of Sanglang?
Yes, your lordship. That's why my representation to that effect was considered, your lordship.
Yes, Mr. Tapin.
These days, lordship, earlier the deputy commissioner, he was a judicial officer before 2010 years. Now the deputy commissioner is mostly, he is not lordship, adjudicating any lordship cases.
Any judicial work.
And workload is very less, lordship. Workload is very less. Only the cases litigation, suppose say one case where the deputy commissioner is party lordship, and then only the communication part of it. Otherwise, lordship, so for parawise and all, everything is prepared by the lordship concerned authority only. And he's the only lordship, caretaker, kind of caretaker only, lordship.
But why the DMO did not accept his joining?
Lordship, as per the information, lordship, the person who is already engaged in the DMO office, lordship, they are lordship, engaged in some particular lordship work, lordship. So they don't want to interfere in the lordship mid of that process, lordship. And apart from that, lordship, the judicial branch is already, lordship, if he is even there, judicial branch will be remain vacant, lordship. So under that circumstances, deputy commissioner and the DMO, they discuss each other, and accordingly this was issued in interest of public, it's administrative agents. And this is his transfer, the proposed transfer to DMO office was also not lordship in the interest of public service, as lordship has said. At his own request, lordship, it was processed.
So
And it's not the case, lordship, in DMO office lordship, the workload is very less. Rather, in office of the DMO lordship, workload is very high.
your lordship, that's a different thing, your lordship. But
Because
when
in the office of the deputy commissioner, there are lots of branches are there. And many are there. But in the office of the DMO, lordship, one person has to handle the things. Lordship, workload is higher than lordship, from the office of the deputy commissioner.
now your
Have
lord,
you filed an affidavit here?
Yes, we have.
yes,
filed. And lordship, so far the region is concerned, lordship. There's a judgment of this honorable court, lordship. Well, it says, lordship, if there is no change of decision, lordship, this is kind of only arrangement only, rearrangement of, resuppling of the lordship. This is the exact transfer.
that judgment is not squarely applicable
And-
in our case.
And,
your
and
lordship.
therefore,
I went
this
through
honorable
that
court
judgment,
says,
your
lordship,
Let him complete.
this situation losses, the region need not to be assigned losses. Otherwise, losses, suppose say one has been transferred, the normal term is of 2 years loss, which is applicable to the petitioner also. He had been in this office of the deputy commissioner since January only loss, not even completed a year loss. And he requested and he was transferred loss, and it was written back. Now losses, suppose say one has been transferred in the mid of this 2 years loss. Then some sort of loss of region has to be assigned because we are deviating from the our set norms. But the case like this loss, when there is no change of station loss, in the same station loss, how the petitioner is prejudiced. In that circumstance, this other process loss, the region need not to be assigned. This is a simple case of resuppling of the lawsuit staffs only in the same office. The same office means the same premises lawsuit. The office is their lawsuit, office of the deputy commissioner.
Same premises.
So same deputy commissioner is the lawsuit in the district lawsuit. He is the head of the district lawsuit, and under their lawsuit, they are also lane and medical. All our lawsuit comes under the umbrella of deputy commissioner. So it comes under one
Office is situated in the same premises.
laws.
No, your lordship, not situated in the same premise.
No, I'm told that lawsuit is situated in the same.
I have been there,
premise.
your lordship. It's not situated in the same premise. The only thing is that I'm not disputing about the station. The only thing was that the workload issue, I'm at the verge of my superannuation. I will be superannuated in the month of June, your lordship, of the next year, your lordship. So till then, it was just my case was that till then, if my appointing authority can arrange me in a work where less workload is involved, then considering my health, I can do the work and I can complete because it's only about 6 or 7 months of my retirement. My case is that I have met that representation. Appointing authority was well within its domain to either to accept or not, your lordship. But once it is accepted, I accrue your lordship, legitimate expectation, your lordship, to be joined at the place where my transfer has been approved. If it has not been approved, then I could not have raised anything because it is completely within the domain of the executives. But it has been accepted, your lordship. Now the case is not of the station. The case is that once the transfer is accepted, whether the acting on the letter of the DMO, which does not assign any reason why my transfer is my joining is not accepted, acting on that letter, whether the deputy commissioner can cancel my transfer order, your lordship. Now, your lordship, there is a catena of judgment of this honorable court itself, which says that cancellation or modification of any transfer order, your lordship, requires reasons to be stated, your lordship, because it is one thing to grant transfer, but it is another thing to cancel it, your lordship. Your lordship, my learned brother has.
It is in his present case may be distinguishable from those cases because it is in the same premises, the same station.
Your lordship, about that judgment, your lordship, because I also went through that judgment, your lordship. In the judgment which is being relied by my learned friend is 2008 2 GLT 786. Your lordship. Here, your lordship, it was besides that, your lordship, no malafide was pleaded, your lordship, in that case. In that case, your lordship, there was the challenge to the transfer in the same station was made on the basis of one office memorandum, your lordship, in para number 2 facts are clear, your lordship. Dear your lordship, particularly para 9, your lordship. Normally, an employer is not under an obligation, para 9, your lordship, to demonstrate the justification for ordering transfer and interference by court is circumscribed, as it is difficult for the court to assess whether the transfer is in the interest of public service. The instant transfer is not being challenged on the ground of mala fide exercise of power or on the ground of violation of statutory provision, but only on the limited ground of not recording justification which is prescribed to be complied when transfer is made before completion of 3 years tenure at one place or station, your lordship. There was office memorandum which says that to that department, your lordship, that was executive engineer, Guwahati Wastewater Resource Division. That particular instruction was there that if in order to transfer any person within a period of 3 years, then a reason or justification has to be assigned by the transferring authority. On that particular office memorandum, only that transfer was challenged, your lordship. But and second is that here the transfer was challenged. My case is different. My case is about the cancellation of transfer order, which has already been issued, your lordship. Your lordship, the Honorable Supreme Court in the recent judgment, 2022-14 SCC 187, your lordship.
Mr. Tagum, you are for respondent number?
Malo, I'm for respondent 3, madam.
DMO.
Yes, madam.
Why you did not accept his joining report?
Madam, the one thing, madam, he's not a staff of the health department. He's the staff of ministry staff of the deputy commissioner. So the DMO is under the medical, the health department, madam. So only in the district matter, as we require the main power, we request the deputy commissioner for transfer. But in this case, his post is not required, but already, madam, expertise we have already engaged, madam. That's why, madam, we have communicated to the deputy commissioner. That's why, madam, in the DMO office, madam, day-to-day, madam, online updatation and other data that the expertise persons require. And for that, he has been in the DMO office for since 2009 till 2004, madam, almost 15 years, madam.
Who?
So there, madam,
No, who
many, the petitioner, madam.
in DM office?
Yes, madam.
Earlier.
Earlier, madam. Now, when we see that so many work is undone, so many works remain pending, madam. So on request, madam, the some expert, the persons required. Accordingly, the transfer was sought for, madam. And another person was replaced. Now he's carrying out the work efficiently, madam. Now, when his service not required in DMO office, DMO is under medical department. Only as and when in all the district, madam, under the control of the deputy commissioner, when as and when there's a requirement of manpower, only we request to the deputy commissioner. Only in that or requisition, transfer is made, madam. In the present case, it's not the case, madam. We are not required of his service now. That is why, madam, we have not accepted. Because had he been the staff of the health department, that is all right. If his transfer is made by the competent, our own parent department, that could be a different thing. It's a normal transfer, but it's not the case, man. Because we're engaging the person who is expert, who is doing well, man. If it's replacement, our work will be jeopardized. And
No, the person who is working in the DMO office, he has not been transferred now in his place.
no, man. My lord, you see, in the
Your lordship, here just I would like to assist your lordship. Your lordship, actually, DMO office or other departments do not have their own ministerial staffs. It is clear from the affidavit of the respondent itself. Your lordship.
23, madam. Page 23, madam. Page 23, madam.
Page 23 of
Page 23 of writ petition, my lord. Sri,
Yes.
number one, sir. Repent and Roy UDC, my lord, establishment DC branch to DMO office, my lord. And Wangdam Jamoy, my lord. This is a petitioner, my lord. UDC, DMO office to establishment of DC, my lord. Now, in his place, this Ripon Roy, my lord, he's working man. And regarding my lord,
So Nitin Roy is already there
my lord,
in DMO office.
Yes, your lordship.
He has not been transferred.
my lord, see. But my lord, see the page 23, my lord. Ripon Roy N. Roy UDC. Present place of posting is establishment branch DC office man. Transferred and posted to DMO office channel by ordered 18 January 2024. And number two, madam, Wangdam Jamoy, the petitioner, madam, DMO office to establishment branch DC office. By this order. And
Nitin Roy is already there then.
Yes.
Android, madam, thereafter, madam, after page 23, madam, page 23, madam, is the first order, madam. 18 January, N. Roy, who was serving as a UDC in the DC office, was transferred to DMO, and petitioner, madam, was serving as UDC in DMO office, was transferred to the DC office, madam. Subsequently, thereafter, madam, on the request of the petitioner, madam, again at page 28, madam.
Yes.
Madam, within a few months, madam. Number one petitioner, madam, DC office, earlier by ordered at the 18 January 2024. He was just recently transferred. Now at 19 July 2024. On his request, madam, Wangdai Jamoy UDC from DC office to DMO, madam. After just hardly 4 months, madam. And N. Roy, madam, was recently transferred, madam. Again, he was transferred at the request of the petitioner. Page,
Yes.
page 28, madam. Page 28. 18 is first, madam, transfer order. Page 23 is first order. Then 28, madam. Within 4 months, madam. On his request, madam. But the transfer or arrangement made on the request of the particular incumbent is not a public interest, madam. Rather, it is treated as although it is not a transfer as such, madam. In a strict sense, madam, it's an internal arrangement. But if it is, even if it is a transfer, madam, it is a malified transfer, it cannot be accepted, madam. It cannot stand in the scrutiny of the eye of law. Because a transfer on the basis of request is a malified and is not an on administrative exigency, and such transfer cannot be done. So here, madam, in this case, madam, at his instance, madam, the subsequent transfer order issue. That's why, madam, when the person is already engaging, my lord.
On what basis you are submitting that request transfer is a nullified transfer?
My lord.
What is the basis of submission that request transfer is a nullified transfer? Not in public interest.
My lord, there's a decision, my lord. My lord, I can furnish, my lord. Decision of our High Court, my lord. 2005 GLC is there, my lord. I can furnish, my lord.
Yes, what is your submission?
My submission is, your lordship, first is that in order to,
Referred the judgment of 2022.
yes, your lordship.
Which paragraph is relevant here?
Your lordship, I'm relying on para number 59. Your lordship.
Para?
Para 59. Oh, para 61, I'm sorry. Para 61. Para 61, your lordship, may I read your lordship? It is tried that state is under the obligation to act fairly without ill will or malice. In fact or in law, legal malice or malice in law means something done without lawful excuse. It is an act done wrongfully and willfully without reasonable or probable cause, and not necessarily an act done from ill feeling and spite. Where malice is attributed to the state, it can never be a case of malice or spite on the part of the state. It would mean exercise of statutory power for purposes foreign to those for which it is in law intended. It means conscious violation of the law to the prejudice of another, a depraved inclination on the part of the authority to disregard the rights of other. Now, para 64, your lordship. This court has held that normally an order of transfer, which is an incident of service, should not be interfered with unless it is found that same is mala fide. It has been held that mala fide is of two kinds, one malice in fact and the second malice in law. When an order is not based on any factor, german for passing an order of transfer and based on an irrelevant ground, such an order would not be sustainable in law. Now here, your lordship, even if my cancellation order was issued for the reason whatever has been stated by my learned brothers, your lordship, that should have been reflected at least in the cancellation order, in the impugned order, because that cancellation was done on the very next day of my approval of the transfer on request. My transfer on request was approved on 22nd of July. Cancellation was done on 23rd of July. When such a action is taken, your lordship, it should have been based on factor, your lordship, German, your lordship.
Mr. Tago, you have filed a affidavit?
My lord, I have not filed, my lord.
On the last
Relied
date,
on
you
the
relied on
affidavit
the.
of DC.
Okay.
Pardon, Mr. Sharma, learned counsel for the opposition. Sir, Mr. Tapin, learned for the respondent number. Mr. Tapin, you have for respondent number?
I'm for lordship 1, 2, and 4 lordship.
1, 2, and 4. Mr. Tago, you have for respondent number 3.
3, ma'am.
Respondent number 3. Argument concluded, order reserved.
Lordship, only one submission. lordship.
Besides this,
So far, the ground of Malapadi is concerned, lordship. It's a settled law, lordship. Until there is made as a party, the issue of Malapadi cannot be considered in absence of the party laws. There's a settled law, Supreme Court. Because allegation has been raised against the DMO laws. But DMO laws, that by person has not been implicated as party in the So, whenever Supreme Court says without implicating.
No, DMO is represented by Mr.
No, it's DMO by post laws. Because Malapadi is always against the person laws.
Not the
Not the post. That is settled law.
Your lordship, besides this, other case laws where there, so can I supply on this ground only, your lordship, the honorable, this High Court has, your
No, you
lordship,
have submitted
one Supreme Court
on this
judgment and
one.
other division bench High Court's judgment was also there. your
Okay, you can furnish to court master.
lordship.
I too will be furnishing one judgment on Malapadi laws.
Okay.
Item number 9 to 12.
This item number 9 is basically an IA. After hearing the parties on the last occasion, this court has observed that entire writ petition can be disposed of because the pleadings are complete. That's how the matter has been listed. It was listed yesterday, but because of the inconvenience of the counsel for the respondent, matter has been fixed today. So Lordship may kindly take up the item number 10, my lord.
My please, Your Lordship. Before making submission by the senior counsel, madam, pardon, senior counsel, madam, there is two IAs. Madam, if Lordship decides entire thing, madam, madam, the case will be finalized. Madam, however, madam, if there is some madam, on some madam, for any other ground, madam, if Lordship, madam, defer the madam, the hearing, madam. Madam, first of all, IA may be considered. IA 200, madam. We have shown some urgency. Two IAs, madam. One IA filed by them, madam, and one IA filed by the Union of India, madam.
IA 200 is filed by?
Union of India, madam.
By them for vacating one of the interim order passed by this court. And in fact, both the parties were heard on 11/11/24. And after hearing the parties, having looked into all aspects, the matter was fixed for final disposal today. The order dated 11/11/2024 passed in item number 11. The decision passed in I. The last list the matter accordingly along with WPC 186/24, 196/24, 108/24 and WPC 3 of 24 in admission column on 3/12/2024. An endeavor shall be made to dispose of these matters on the next date. So, the otherwise matter is would not take much time to hear subject to the convenience of the court. The facts are such, my lord. The respondent number 6, he was awarded a contract for construction of a road from Tato to Mesuka. And as per the contract agreement, there is a provision for subcontracting a portion of the this road construction project. Now, the present petitioner. Can you proceed, madam? No. Now, prior to submission of the tender, the present petitioner and the respondent number 6 had an understanding, and they have in fact had an MOU that tender would be submitted in the name of the respondent number 6. And if the tender is awarded, in that case, the present petitioner will be executing it on back-to-back basis, the entire project. And for that purpose, the necessary security deposit or the performance guarantee, whatever is required, that will be deposited. But now, after entering into the contract, what it appears that the subcontract has been approved only to the extent of 49%. And before that, I have already, as per the MOU, I had submitted the total the BZ. And therefore, I have submitted an application before them that this was on the condition that the entire work I'll be executing. So I had deposited the full bid security. So proportionate 49%, retaining the 14%, remaining I should be allowed to withdraw. Now it was stated by them that unless you execute the work to the extent of 49%, that this bank guarantee cannot be allowed to be withdrawn. So the things proceeded,
And though the word is used as well as subcontract, as because in the contract agreement, it is said that it can be subcontracted, but there is no subcontract agreement as such which has been approved by the BRO. Absolutely no agreement is there. And this MOU also, my lord, cannot come into play because that was prior to, my lord, submission of the tender, and the stipulation was that the entire project would be allowed to be executed on back-to-back basis. So now, my lord, during the proceeding, my lord, the main contractor, I was given 49% of the work to execute. I have started commenced my work. So far as the main contractor, it is respondent number 6. He did not do a single work in the project. And ultimately, the tender, my lord, as per the tender condition, the work allotted to him, awarded to the respondent number 6, has to be terminated. Your lordship will find, my lord, first of all, your lordship will see, my lord, the approval order, my lord, at page 48.
Forty-eight of
48 of the writ petition, my lord, in my lord, item number 10. And before that, I may take your lordship to, my lord, 2 of the, my lord, statement I have made in the writ petition which have not been denied. Paragraph 10, my lord.
yes.
That the petitioner state that it has been submitted. It has submitted the bank guarantee to the extent of rupees 2 crore 3 lakhs 49,000 as per MOU executed between the petitioner and the respondent number 6 on a clear understanding that the petitioner will be allowed to execute the entire work on the back-to-back basis, and was absolutely in dark as to the clauses in the contract agreement that the respondent number 6 cannot subcontract more than 49% of the said work. Therefore, on receipt of the aforesaid letter dated 7/10/2021, the petitioner intended to withdraw the aforesaid bank guarantee with the permission to resubmit proportionate bank guarantee to the extent of work approved. However, the respondent authority denied the said request on the ground that such request can only be accepted after subcontractor completes the approved work. But this has not been denied by them, madam. Now, your lordship will find, my lord, the page 48 is the subcontract. Approval of the subcontract, my lord, page 48. Page 49, paragraph 3. The proposal has been examined in the light of provision under clause number 4.2 of EPC agreement under CA number so-and-so. The proposal submitted by firm to allow Messrs. Petrodumpen Enterprise, B sector, that is present petitioner, near Rajbhavan, Arunachal Pradesh, to execute the subject work as subcontractor is in principle agreed for the subject work to the condition that subcontractor shall not be allowed to execute the work more than 49% value of the work project. However, the EPC contractor, Messrs. Velacha Engineering Limited, shall at all times be responsible and liable for all its obligation under the contract agreement. It is just because of the clause 4.2, which I have quoted. Your lordship may kindly have a look to the clause at page 12.
Yes.
4.2, obligation relating to subcontracts and any other agreements. The contractor, whether a joint venture or sole, shall not subcontract any works in more than 49% of the contract price. This clause, my lord, is incorporated in the contract agreement entered in between the, my lord, respondent number 6 and the BRO, my lord, the respondents, my lord, which we were not aware at the time of, my lord, MOU. Price shall carry out works directly under its own supervision and through its own personnel and equipment at least 51% of the contract price. Further, in case the contractor is a joint venture, then the legal member shall, Lordship may skip this, my lord. Then Lordship may come to, my lord, subclause 4, my lord. Page 14. It is expressly agreed that the contractor shall at all times be responsible and liable for its obligation under this agreement, notwithstanding anything contained in the agreements with its subcontractor or any other agreement that may be entered into by the contractor, and no default under any such agreement shall excuse the contractor from its obligation or liability under this agreement. However, in case of non-compliance of the contractor towards his obligation for payment of the approved subcontractors, which is likely to affect the progress of works, the authority reserves the right to intervene and direct the contractor to release such outstanding payments to approved subcontractor out of the payments due to the completed works of the interest of the workman. So, notwithstanding the subcontract, the entire responsibility is with the contractor, and it will be done under the active supervision, etc., my lord, of the contractor. And my lord, however, in case, my lord, there is a dispute with regard to the payment, in that case, authority will intervene and they'll make such order or direction so that, my lord, the subcontractor, the work doesn't suffer, my lord. Now, during the execution of the, my lord, work, the respondent number 6, my lord, did not, my lord, paid to the, my lord, petitioner a certain amount. So therefore, a, my lord, application was submitted before the, my lord, authority. And and the authority also, my lord, directed the respondent number 6 to, my lord, make the payment, but no other effective orders had been, my lord, taken, my lord. The lordship will find, my lord, page 107, my lord. Hundred and ten.
110?
110. This is the letter, my lord, on the complaint by us, my lord. 110, my lord. Refer Messrs. Pedro Enterprise, letter number so and so, Messrs. Pedro Enterprise, via above mentioned letter informed to authority that Messrs. Velasa Engineering Limited are not released the payment to the subcontractor as per MOU signed by both the Velasa Engineering Limited and subcontractor while operating of escrow account number so and so. As per terms and condition of the opening escrow account with Indian Bank is clearly mentioned in para 8 that 3% funds to be transferred to Messrs. Velacha and 97 funds to be transferred to Petrodump and Enterprise whenever authority releases the payment to each SSP IPC. This SSP, SPS and IPC are abbreviation for the stage payment, and the IPC is the interim payment. These are the two different modes. At different stages, the payments are made, that is SPs, and IPC is interim payment. In intimation to this issue regarding release of payment to subcontractor has been raised and communicated to you several times, but you have failed to settle the issue with the subcontractor. In this context, this headquarter letter number 30th May 2023 regarding payment to subcontractor, Mr. Sahabuddin may also refer. In that view of the matter, it is directed to release the balance payment of works executed by subcontractor at the earlier and submitted your feedback to this headquarter on so and so date. Notwithstanding this direction, my lord, the contractor did not pay. We have made Captain submitting representation. The one, my lord, we have also submitted on, my lord, at page 107, which you will find. That was, my lord, submitted by us. Then 122, my lord, is again the my lord, request for my lord. To my lord, release the BG, etc., my lord. And prior to that, what happened, my lord? The notice of termination was issued to him, my lord. And that also, my lord, though my lord, response was submitted by them. And it was also, my lord, the respondent number 6 has submitted that the petitioner has, as a subcontractor, has completed, my lord, 49%, and my lord, he is now ready to do the execution of the 51% of the remaining work. So, in spite of that, my lord, the authority, my lord, ultimately terminated the contract, my lord, by order dated 16/12, my lord, 2023, at page 127. And relevant, let me come to 134.
And then in 30?
134, relevant would be, my lord, 134. Paragraph 12, my lord, last paragraph.
Yes.
Whereas as per clause 4.2.1 of EPC agreement, the contractor, whether joint venture or sole, shall not subcontract any works in more than 49% of the contract price and shall carry out works directly under its own supervision and through its own personnel and equipments in at least 51% of the contract. Accordingly, as per provisions, the subcontractor Petrodumpen Enterprise was allowed to execute the work as subcontractor to the condition that the subcontractor shall not execute the work more than 49% value of the works and 51% of the works to be executed by the main contractor, that is Valesa Engineering Limited. The stretches on which the subcontractor has executed their work is also not provided to the authority to monitor the progress of subcontractor, and similarly, main contractor has provided the stretch was a plan of execution of 51% part along with induction of resources till date. The overall physical progress of the work is 26.2%, 21%, and totally done by the subcontractor. It is an admitted fact that not a single portion he has made any work. It has been done only by the subcontractor. Now, after termination of the contract, we have, my lord, having come to know that contract has been terminated, we have submitted our representation that since the entire work, whatever we have done, that should be paid to us so far as SPS 8 onwards, 7 onwards. And they did not do anything. Ultimately, we had to file this writ petition. Now, my lord, few things, my lord, what is, my lord, is important. First of all, my lord, we don't have any contract with the respondent number or respondent BRO, my lord. We have executed as a subcontractor, and from the day one, it is an admitted position that the 26.1%, that is up to a particular date of April 2023, not till the date of termination. So that has been worked by us. So we have claimed the payment. They did not do anything. So we have approached this honorable court. And my lord, the various stages, my lord, how the matter has been proceeded before this court. My lord, will find the order sheet, my lord, different, my lord, orders passed in this case, my lord. At different stages, how the matter has been progressing. The first order, my lord, is at the order dated 5/1/24. The Honorable Court has taken the note of the fact that the entire amount was submitted as a BG amount that was submitted by the petitioner from his account. Taking note of that, my lord, so far as the my lord, encashment of BG as per the agreement between the respondent number 6 and the BRO, that had been stayed by this order dated 5/1/2024. Then your lordship will find, my lord, they have filed in the meantime, they have also filed, my lord, the written state of the affidavit in opposition. Their whole contention is that there's no, my lord, contract between the present petitioner and the BRO. So therefore, they are not going to my lord, pay. At different stages, they try to say that termination payment matter is there that is governed by the contract. So all the contract agreement they are trying to impose on us. Then your lordship will find on 4/3/2024. We had also filed an IA, my lord, this 4/3/24, perhaps in the IA 24 of 24, my lord. Mr. So-and-so learned as DSGA appearing for the respondent number 124 shall file an additional affidavit on behalf of the respondent number 124, highlighting as to why the payment for the works as done by the petitioner as subcontractor duly approved by the authorities shall not be released to the petitioner directly, and conducting as joint verification of the part of the work as executed by the petitioner. But pursuant to that, my lord, they have conducted, my lord, joint verification. My lord. Initially, they did not, so therefore, my lord, their order was passed. Lordship may kindly similar order dated 22/4/24 in IA 24. My lord.
IA 200?
No, IA 24 of 24. My lord. Order dated 22/4/24. Now, your lordship, CD order dated 22/7/24, my lord. Passed in WPC, my lord, 3 of 24. Your lordship.
Yes.
Second paragraph. In terms of the direction passed by this court, it is brought on record that a joint verification was carried out with regard to the works as stated to have been executed by the petitioner herein as subcontractor, and a report thereof has been placed on record. So in so, my lord, learned DSGA submits that the Mr. Petitioner appearing for the petitioner submitted that quantity of work as executed in the matter being unbilled. The petitioner has submitted his bills for the purpose before the authorities, and the same is pending consideration. Mr. Kato Learners at DSGA submits that the authorities be granted at least 2 weeks time to process the bills of the petitioner in light of the joint verification report and pass appropriate orders thereon. No order has been passed, my lord, pursuant to the joint verification report, which was, my lord, brought on record by an affidavit. That's six.
Additional
By way of additional affidavit, page কিমান হ'ব?
File 31st May.
No, page. It was filed on 1/6/2024.
Yes.
Now, joint verification, you also will find internal page 4. This is the joint verification they have done, my lord. Though we are not satisfied, but then, my lord, we are not going to dispute on the actual verification or not. But at page 13, your lordship will sign. Page 13 of the affidavit, paragraph 4.
Yes.
The entitlement of payment to the petitioner cannot be ascertained by respondent number 2, 3, and 4, as there is no agreement between the petitioner and the respondents. The petitioner was engaged by Messrs. Velasa Engineering Limited directly under their own mutual understanding. The petitioner was approved to be engaged by Messrs. Velasa Engineering Limited as subcontractor by respondent number 3 as per clause 4.2 of the contract agreement number so and so and so. So the order said, the payment, the bill was submitted, the valuation has been done. Why you have could not do it? So this is the only report in the valuation. While doing the valuation, they have said that agreement is not there. So therefore, the payment cannot be done. Now, my whole submission would be, admittedly, there is no agreement between the respondent BRO and me, but they have approved me to execute the work. So I have lawfully executed the work, and this was not for any gratuitous purpose. And the work that I have executed, they have received. So therefore, under section 70 of the Contract Act, I satisfy all the 3 conditions. Any thing, they want to take action against the respondent number 6, they can do so. We have made him a party. They have not come. They appeared some days. Then they have abandoned their appearance. We being not a party to the contract, the petitioner being not a party to the contract, you cannot impose those conditions on me. But if I satisfy the basic requirement of section 70, in that case, I am entitled to the payment.
Next one.
Section 17. 70. Obligations of persons enjoying benefit of non-gratuitous act. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoy the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the things so done or delivered. That is my whole case, my lord. In support of this, my lord, submissions, my lord, I'd like first, my lord, what are the ingredients, my lord, that has been, my lord, discussed in the Union of India versus Sitaram Jaiswal case, my lord. Year 1977, Supreme Court, 329. Paragraph 6.
Yes.
The three ingredients to support the cause of action under Section 70 of the Indian Contract Act are these. First, the goods are to be delivered lawfully, or anything has to be done for another person lawfully. Second, the things done or goods delivered is so done or delivered not intending to do so gratuitously. Third, the person to whom the goods are delivered enjoys the benefit thereof. It is only when the three things are pleaded in the plain and that a cause of action is constituted under Section 70 of the Indian Contract Act. If any plaintiff pleads the three ingredients and proves the three features, the defendant is then bound to make compensation in respect of or to restore the things so done or delivered. Now, let's see the scene, right? Works that I have done as per the approval, it is not that I have unlawfully I have done. I have lawfully done. It is not a gratuitous act because I have invested entire things, my lord. And thirdly, my lord, they have received the works that I have done. On the same point, my lord, AR 68, 1968, 1218. They also, my lord, the paragraph 6. My lord. Paragraph 6. In our opinion, reasoning adopted by the trial court and the high court for rejecting the claim of the appellant is not correct. It is now well established that where a contract between the Dominion of India and a private individual is not in the form required under Section 175(3) of the Government of India Act, it was void and could not enforce, and therefore the Dominion of the Indian cannot be sued by a private individual for breach of such a contract. It was stated in the case that under Section 175(3) of the Government of India Act 1935, the contract had to be expressed to be made by the Governor General to be executed on behalf of the Governor General, and C, to be executed by officers duly appointed in that behalf and such manner as the Governor General may direct authorize. May I skip, my lord, this portion, my lord. That is under the thing, my lord. At page 7, my lord.
Yes.
The 10th line from top on the left hand side, mirror. It starts with, but if money is deposited and goods are supplied, or if services are rendered in terms of void contract, the provision of Section 70 of the Indian Contracts Act may be applicable. Well, even if the contract is void, then also Section 70 will be applicable. In other words, if the condition imposed by Section 70 of the Indian Contract Act are satisfied, then the provision of that section can be invoked by the aggrieved party to be void contract. The first condition is that person should lawfully do something for another person or deliver something to him. The second condition is that in doing the said things or delivering the said things, he must not intend to act gratuitously. And the third condition is that other person for whom something is done or to whom something is delivered must enjoy the benefit thereof. If these conditions are satisfied, Section 70 imposes upon the latter person the liability to make compensation to the former in respect of or to restore the things so done or delivered. Our High Court also has there are some many other judgment, my lord. I'm not reading. I'll give a citation, my lord, here. 1989 2 GLJ 70.
Not necessary to multiply the.
Lordship, my lord. Therefore, my lord, this only to, my lord.
When there is judgment of Supreme Court on the point,
Yes,
where is the point for
Lordship,
applying the judgment?
there are many other judgment, my lord. Year 96. I am not making it lengthy, my lord. There's another case, my lord, of the Supreme Court where beyond the contract, some other additional work had been done. It was refused. Trial court also said it is not, cannot be done. Supreme Court has no. Since he has done the work, again, you have received the work that has been done, the benefit. So you are bound to pay, my lord, make the compensation. There is AR 66, Supreme Court 1034. Then thereafter 2007, my lord, even including 2019, my lord. Now, your lordship will kindly find there's though in this case several pleadings at different stages have been filed. Their only objection is that we don't have any agreement with them. If we don't have an agreement with them, so my lord, I am covered by the section 17. Now, from the last order, my lord, there was an observation that although the work has been measured, the valuation has not been done. They have filed, my lord, an affidavit in this case. This time they have given the valuation, the work that I have executed.
Affidavit dated?
Affidavit dated, my lord, last certificate. Interestingly, while computing my entitlement to, my lord, 13 crores and all, in terms of the contract agreement, they have deducted something, my lord, 12 crores or something. Only I have been made entitled to 2 crores and odd. So the whole purpose behind, my lord, all this, my lord, non-payment, non-paying me only to make me suffer. What they have done, my lord, right from the day one of the contract, the principal contractor did not execute a single portion of the work that is admitted in the termination letter that I have seen, I have shown, my lord. They have not done anything. They should have taken action against them, or they should have, my lord, objected, my lord, of execution of the work by me. They did not do so, my lord. They have allowed me to continue. And I have completed my 49% of the work. And at the fag end, when I am requesting for the, my lord, payment, now they are coming up with the plea that there is no agreement. And these things have all come into the, my lord, now to the light. The whole purpose is to deprive the petitioner from the due payment. The joint
Both his
valuation,
judgments are on the point on section 70.
my lord,
Both his judgments on the point on section 70.
lordship, my lord, 70. That is my whole case, my lord. That is the, my lord, they have not denied any of the, my lord, things. They are not saying that we have, my lord, fortuitously done or gratuitously done, my lord, the work, or we have submitted false bill, or we have already got the payment from the, my lord, original contractor, etc. The payment they have not done. They are different stages by the pleadings, my lord. I am not taking a lordship because it will take long time.
You were referring to an affidavit.
My lord?
You were referring to an affidavit.
My lord, the last one to only to show their intention of, my lord, non-paying me, my lord.
No, what was the amount due?
This is 11 crore 83 lakhs 38,000 098 at page 199.
Of the main petition?
Yes, perhaps this is serially they have maintained 199 in the original case. Otherwise, the affidavit dated 2/12/24.
$199 Annexure D.
Annexure D, my lord. They have made the valuation to 11 crore 83 38 098. And thereafter, your lordship will find all the deductions they have made. These are all in terms of the, my lord, contract agreement. And what payable they are showing at page 200 is 3 crore 16 lakhs 16,000 and odd, my lord. Now, these are, my lord, this petitioner is a local contractor with all hard earning. In the other case, I have so many cases have been, my lord, filed by the, my lord, borrowers from whom I have, my lord, taken the loan, my lord. With all this, my lord, diligence, we have executed the work. They are not taking any action against the, my lord, principal contractor. At the end, my lord, here also what they are saying, I should approach the, my lord, contractor, they will pay to the contractor.
So after deduction, you are entitled to rupees 3 crores, 16 lakhs, 16,535.
According to them, my lord, these deductions. But
Yes.
otherwise, the work I have executed, according to them, that is 11 crore 83 lakhs
So
38,000.
you agreed to this amount.
My lord,
You have agreed to this amount.
my lord, 11 crore 83 38, my lord, since they have assessed, my lord, even if I dispute, my lord, if my lord, this court may not go into that, my lord, for that purpose, I'll be going for the civil court, my lord, because I still, while submitting the joint verification report, I objected to it. But disputed question of, my lord, now I cannot go into that. So this 11 crore 83 lakhs 38,000 for, my lord, moment, my lord, it is an admitted amount that this much, this is an admitted amount. That the works has been, according to them, work has been done to the extent of 11 crores and all. But now they added all this deduction. That is pursuant to the contract agreement which have been entered between the respondent BRO and the valeture. It is not their case that they have paid to valeture and still we are asking. It is not the case that I have not executed the work, then also I am asking. This is not their case that they are not authorized me to execute the work. Then also by some means, I have unlawfully I have executed the work. Only ground that in the joint verification as well as in the pleading that the agreement is not there. If you have anything to say, you go and say to the principal contractor, respondent number 6. I have given all the allegations against respondent number 6. He is also made party. He has not come forward at all, madam.
So he is not before this court.
No, his party received summons on some day, some occasions appears, the order sheet would reflect, some occasion council represents, some occasion they don't. Otherwise, notices have been served. 2-3 occasions perhaps they had also appeared. And so far as our bill is concerned, my lord, we have submitted as they reflect the order also, which was filed on 22/7/2024. Though it is much more than what the admitted amount. According to the, we are to receive 38 crores 57 lakhs and all. First objection there came that they cannot go for joint valuation unless the respondent number 6 makes an application for termination of payment. This court having heard the matter, then said you go for a joint verification. Then they said that we cannot make the payment without the bill submitted by the respondent number 6. Then this court said you assess the value and specifically for payment to the petitioner. What is there, so much of inclination to the respondent number 6? They are neither taken any action nor declared as a non-performer or blacklisted, nothing. He is free. So far as I have executed, admittedly 26% works I have done. That is also till the 26th April. The measurement has not been taken till the date of termination of the contract. That was on 16/12/23. So 6 month value. So ultimately, whatever happened, my lord, the joint verification has been done rightly, wrongly. Evaluation has been arrived. 11 crores they have assessed, which is admitted amount. They should pay to us. That is my prayer. Otherwise, my lord, these small contractors, my lord, who, my lord, as a subcontractor, try to enter, my lord, at the thresh of this, my lord, respondent and the giant contractors, my lord, they'll not be able to execute anything. After submission, my lord.
Yes, Mr. Kato.
May I please, your lordship?
Lordships to, the clear understandings of the facts of the case, madam. Again, my lord, may I come to the matter, very picked of the facts of the case in brief, madam. Madam, for construction of road and upgradation of madam, the Tato Mechuka Road, which is national madam, strategic importance road, madam, as earmarked by the madam, the Ministry of Defense, madam. For that, madam, the NIT was invited, madam. And the NIT for the whole stretch of the road, madam, two packages, package number 3 and package number 2, madam. Package number 3 has been awarded to this contractor, madam, with an estimated cost of madam, 67 crore 83 lakhs was madam, basically awarded to madam, the respondent number 6, Valencia, madam, who is the principal contractor, madam, for execution of madam, this entire work with estimated cost of 67 crore 83 lakhs, madam. Thereafter, madam, what happened, madam, the formal agreement was entered into between the parties, madam, wherein, madam, admittedly, the petitioner is not a party, madam. As per the, madam, the contract agreement made between the respondent number 6 and the department, the work has to be executed, madam, entire stage of work, entire stage of road, madam. Madam, out of that way, madam, the petitioners was allowed to, madam, the execute work to the extent of 49%, madam. This consent has been given by the petitioner as well as the main principal contractor, madam. So therefore, madam, it is our submission time and again before this honorable court, we don't have any, madam, the privy to the contract to the, madam, the petitioner, madam. Petitioner is, madam, is a subcontractor being allowed by the principal contractor, which has been, madam, allowed by the department to execute the work to the extent of 49%, madam. 51% has to be executed by the principal contractor. It is their internal agreement made between the, madam, the respondent number 6 and the petitioner that 49% of the work will be executed by the, madam, the petitioner, madam. Thereafter, madam, as per the contract agreement, madam, it is not to my limited understandings of the, madam, the very fact of the case is, and the understandings of the section 70 of the, madam, the contract agreement, madam, that will be, madam, governed when, madam, the, madam, work has been executed without there being any agreement, madam. NIT was plotted, they duly participated, found to be, madam, the responsive bidder, work has been awarded, a contract agreement was entered into, by which, madam, the entire things will be governed by the contract agreement, madam. As per the contract agreement, BG has been submitted, madam. As per agreement, work of specification, madam, has to be executed. And as per that contract agreement, madam, the work, as per specification, madam, work has been carried out by these petitioners to certain extent, not 49%, madam. So therefore, madam, the petitioner, madam, the claimings by way of this writ petition, madam, 3 aspects, madam. First is, madam, as per the period, releasing of the, madam, the BG amount, madam. And the second is, madam, the unpaid bill has to be paid, madam. Madam, milestone was not achieved by them. None of the, madam, the petitioner as well as the main principal contractor, Valencia, madam. Admittedly, madam, we don't have any contract agreement with the petitioner. Madam, the work has been allowed to executed by to the petitioners by the respondent number 6 in consultation with the department. So therefore, madam, admittedly, madam, there is no, madam, the contract agreement between the, madam, the petitioners and the department. Madam, principal contractor is when the principal contractor is already existed, madam. Through that, madam, the petitioner has executed the work, madam. Thereafter, madam, milestone was not achieved. Madam, ultimately, the resulted into, madam, the termination of the, madam, the contract agreement, madam. After, madam, contract agreement, as lordship knows, once the, madam, the contract agreement, madam, entire rights are being, madam, decided, madam. So therefore, madam, there is no liability as such to make payment, madam. However, madam, as claimed by the petitioners that some portions of the work which has not been, madam, till the termination of the contract agreement, madam, unbilled portion of some, madam, work was not billed, madam, before the termination was issued. That, madam, portion has been, madam, the portion was executed, madam, joint verified, verification was carried out, as per direction of this honorable court, the joint verification report is also filed before this honorable court by way of additional affidavit, my lord. My lord, unbilled portion amount was my lord, verified as per the order of this honorable court, wherein, my lord, the work was quantified, my lord. And after calculation, my lord, this honorable court has given directions to the, my lord, departments to, my lord, quantified in terms of the cost. My lord, cost has been ascertained to the tune of, my lord, 11 crores, my lord. My lord, final, my lord, agreement, my lord, the final, my lord, clear picture is our additional affidavit, my lord, which has been filed recently, my lord. Therefore, my lord, may I take your lordships to the additional affidavit filed by the Union of India, wherein, my lord, it has been clearly mentioned that, my lord, senior counsel has already referred, my lord, but for sake of, my lord, clarity, my lord, I am again referring, my lord. Additional affidavit, my lord, internal page number is page number 196, my lord. Obligation relating to, my lord, the subcontract and any other agreements, my lord. This has been, my lord, specified. This is also part of the agreement, my lord. I'm sorry, my lord, the all entire, my lord, that is the contract agreement documents is voluminous, my lord. Only extract portion is, my lord, annexed is annexure 1. Wherein, my lord, there is a recognition between the parties, my lord. 49% of the work will be allowed to execute it by the petitioner, my lord. Clause, my lord, for 4.2 A1, clause subclause 1, and, my lord, subclause 4. It is expressly agreed that the contractor shall at all times be responsible and liable for its obligations, my lord. Under this agreement, not with its standings, anything contains in the agreements with its subcontractors or other agreement that may be entered into by the contractors, and no fault under any such agreement shall excuse the contractors from the obligations or the liability under this agreement. However, in case of non-compliance of the contractors towards his obligations for payment to the approved subcontractors, it is likely to affect the express progress of the works. The authority reserves the right to interfere and direct the contractors to release such outstanding payments to approved subcontractor out of the payment due for the completed works in the interest of work. But what I wanted to point it out is, it is not out of the way that the principal, the petitioner has been allowed to execute the work. The work allowed to work execute, allowed to execute the work out of this agreement. And another termination part, once the termination, of course, senior counsel has not raised that issue, the termination, once the contract is terminated, entire matters ends there, Now the bill quantified by the respondent department is, internal page number 199, Rightly pointed out, this is the amount, after verifications, there is a clause wherein, the deduction has to be made, So once the bill, unclaimed bill, unbilled amount was verified, accordingly that has been quantified, and it has been, converted into the terms of cost. And as per the, cost calculated by the department, this has also not been, disputed by the petitioner, in fact, Deduction, the total amount, serial number 5, total amount, 11 crore, 83 lakhs, 38,000, And after deductions, deduction starts from page, serial number 6 up to, serial number 15. Now, after deductions, this is the amount, payable to the petitioner, This, part, neither petitioner is disputing nor, we are, disagree, We are ready to pay this much amount. Now the question is payment of the amount, after calculation, At the time of termination of the contract agreement,
You were agreeable to pay this amount,
this amount, this has been worked out by the department.
3 crores, 16
3
lakhs.
crores, 16 lakhs, and 16,535, This is the work, my lord, and the amount quantified by the, my lord, department and converted into the cost, my lord. Now, my lord, regarding the payment portion, my lord, of course, my lord, respondent number 6 is not before your lordship. However, my lord, respondent number 6 is also the made as who is the principal contractor, my lord. He has been made as one of the respondent, my lord. But my lord, as per the contract agreement, my lord, there is a provisions for the payment of the, my lord, the escrow account, my lord. Whatever, my lord, the amount paid to the petitioner, it has been paid through, my lord, the escrow account opened by the, my lord, the principal contractors in consultation with the department, my lord. So therefore, my lord, the work executed by the petitioners till, my lord, date, it is 26%, 26.21%, my lord. This they are also not disputing, my lord. Of course, my lord, 49%,
26
my lord, 26.21%, my lord.
So where is that document?
This appears in the termination order itself.
Termination order is at page number
127.
of the main repetition.
Yes, my lord.
Lordship.
127.
127. Relevant is 130.
Hmm.
There, well, this 26.21%, that is as on 27th April 2023. And I had continued, my lord, till the date of termination on, my lord, 16/12/2023. So these measurements were never taken. And this observation, my lord, that this 21.6% has been done by the petitioner alone is at page 135. Fourth line from
Page 130.
135. 130 is the, my lord, the 26.21, which was assessed till 27th April 23. That reflects in page 130 against serial number 2, milestone 2. Not on the date of termination, my lord. And this 135.
This is up to 27th April 23.
No, my lord, this 26.21% has been taken as on that 27th April.
27 April.
27 April. Remaining was not assessed. Therefore, the joint verification was necessitated, and this court, after hearing, my lord, this joint verification was to be
What is
done.
that report?
My lord, this is the joint verification report, my lord. We have, they have
My lord, in our additional affidavit.
additional affidavit, my lord.
When you were referring to page number 135,
Yes, my lord, to show that the fourth line from top, the overall physical progress of the work is 26.21 and totally done by subcontractor. That is me, totally. Not a single work by the principal contractor.
that paragraph number?
But the first paragraph, line number 4 from top.
135.
135.
34 or 35?
35, 135. Line number 4. Sentence starts with the overall physical.
Your paragraphs are there, paragraph number?
It is just above paragraph 13.
26.1%.
Yeah, the overall physical progress of the work is 26.21% and totally done by the subcontractor. The main contractor has not executed any work on ground. Now then also they want to pay the remaining to the main contractor. They have not done anything. They did not declare any non-performer nor blacklisted, nothing. And since from the day one, the work was, the LOA was issued on 22/2/2021. Thereafter, he did not execute any work. They did not take any action against the principal contractor, and they poured this local subcontractor by investing all the money. They have been enjoying the work. They have received the work, and all the terms what he is referring, that is to the reference to the contract agreement between the respondent number 6 and the BR, not with me. So therefore, they can realize all whatever as per the termination order, whatever clauses empowers them to realize the amount from the principal contractor, they can go ahead. big company, big things, my lord, they know how to realize. The government has full machineries. No one is, my lord, stopping them from realizing. But why from me, from whom you have got the work without there being any contract with me? The subcontract clause 4.2, what he has also referred, I have also referred, only to show that my entry was, my lord, the execution of the work was lawful. There is no other separate agreement with me and the BRO, whereby they can say that in spite of you work, we will not pay to you, we will pay to the principal contractor. Rather, the approval letter, again, if your lordship looks into 48, at page 48, I'm just reiterating. Should not be, but then, my lord, it's a hard case, my lord, persons, my lord, how they are suffering, my lord. Page 48 is the approval letter. Page 49, lordship may come paragraph 4. However, the EPC contractor Messrs. Velecha Engineering Limited said at all times be responsible and liable for all its obligation under the contract agreement. It is only the Velecha, you execute, you realize everything, you make him a non-performer, blacklist him, seize his property.
Malad, may I continue?
Yeah.
Malad, admittedly, this is not the case, Malad, wherein Malad, the petitioner has been allowed to enter into the contract agreement, Malad, allowed to execute the work to the tune of Malad, to the extent of 49%, Malad. No, Malad, because of this Malad agreement, because of Malad, this contract works, Malad, petitioner has been allowed to Malad, entered into Malad, for execution of 49% of the work, Malad. So therefore, very much of the terms and conditions of the Malad contract agreement will govern to the petition, original Malad principal contractor as well as the subcontractor Malad. That is Malad, the whole thing. And regarding Malad, to the extent of the work executed by the petitioner is Malad 26 point Malad has already taken out of that Malad the portions of the work 26.21 Malad out of 49 Malad. Now, Malad, only to the extent of 46 Malad, now the all balance work has to be executed by the department Malad. This is all because of the Malad, the principal contractors Malad, who default in the execution of the work Malad. Department is also suffering Malad. Till that Malad, therefore Malad, we prepared an IA in the other case. Malad, till now Malad, we are not in a position to execute the work Malad. So therefore Malad, the department has Malad fairly executed Malad, calculated the remaining bills to be paid Malad. Therefore Malad, what the department has taken stand on that issue is Malad, clearly reflected in our affidavit Malad, page number 4. Lordship may kindly page number 4 of my affidavit, Malad. Original affidavit. First affidavit, Malad, filed by that date. It is not that, Malad, at the time of termination of the contract agreement, Malad, Malad, and that thing was not Malad, calculated. And that thing was calculated. After calculations, Malad, the contract agreement has been terminated. After assessment of entire thing. With regard to the statement made in the read petition number, answering the states that MS Peto Dampo Malad petitioner that the work was executed more than 49%, whereas the total reported progress of the work completed as per specifications as on the date is 26.21%, for which the payment has been released to the petitioner Malad. We are saying that the amount has already been, so far Malad, the amount paid to the petitioner is Malad, more than Malad, the amount actually he entitled Malad. And Malad, may I continue, Malad? No further bill has been submitted by the contractors regarding any further progress of the work, Malad. This was the actual and the initial step taken by the Malad department. In the matter of timely payment, this headquarters raised the issue with the Palacia Engineering Limited and communicated accordingly to the Petro by letter number so and so, that is annexure 3 and annexure 4. Malad, I will not Malad, going to depth that. Malad, after annexure 5, Malad, married Malad. The valuation of the unbilled and partially completed works as per clause 23.5 of the contract agreement has been carried out, and the payment due, if any, after making deductions for non-achievement of the milestones, non-rectifications of the damages, and other statutory deductions will be made to the petitioner's respondent number 6
after submission of the requisite documents as per contract agreements by the respondent number 6. Now, my lord, I'll post for a moment, my lord. My lord, if work has been executed by the petitioner or the principal contractor, this has to be, my lord, the bill has to be submitted, my lord, compliance, the entire things through respondent number 6, my lord, who is the principal contractor, my lord. We don't have any, my lord, the direct business with the petitioners, my lord. So therefore, my lord, the entire things has to be, my lord, the routed through the, my lord, respondent number 6, who is the principal contractor. So therefore, this is the time and again, Malad is still taken by the department that the amount, if any, is to be paid, Malad, that has to be paid through the respondent number 6. And Malad, so far we have paid the bill amount, Malad, is through Malad the escrow account. So department is ready to deposit the amount which has been calculated. The Lordship has already seen the amount to the tune of Malad 3 crores 16 lakhs 16,000. That we are ready to pay, Malad, through the escrow account. Then, the receiving of the amount is basically on the part of the respondent number 6 and the petitioners. So therefore, that is the whole contention. The entire affidavit which we have filed is very much clear and transparent. That we are we don't have any the direct obligations with the petitioner. The direct obligation is respondent number 6 as per the contract agreement, and we cannot go beyond the scope of the contract agreement made between the department and the respondent number 6. And if mutual agreement was made between the petitioner and the respondent number 6, it is not our domain of the respondent department.
Just a short reply to that, because I did not, just wanted to highlight the main issues. Now he has open different aspects.
A minute. What is your stand on this section 70 of the contract?
As I have already pointed out, it is not the clear case of the petitioners in the respondent department. Out of the way, the work has been allowed to execute. Work was allowed to execute as per the NIT issued by the respondent department, wherein the respondent number 6 participated, found to be the responsive bidder. Accordingly, contract agreement was entered into between the respondent number 6 and the department. By virtue of that contract agreement, the petitioners came into the picture, and he has been allowed to execute the work to the extent of 49%, which he has not done. However, by virtue of that agreement, the petitioner has been allowed to execute the work. So therefore, section 70 is completely is different aspect when there is no such contract agreement, when there is no the direct contract NIT floated by the work has been benefited. Therefore, we are ready to pay. It is not the case of the we are not denying that he has not executed the work. Of course, he has not executed the work as the milestone fixed by the department. That has not been achieved. So therefore, contract agreement has been terminated. So therefore, section 70 is completely and purely is in case where there is no such agreement made between the parties. So therefore, that contract section 70 is.
To you, section 70 is not detected here.
My lord. It's because it is very much the root of the allowed to work, execute the work is by virtue of the agreement wherein the petitioner has came into picture. Approval has been granted admittedly, after all we want the execution of the work.
So, can you take such a stand after approval? Can you take such a stand after approval? So you have approved subcontracting.
To my limited understanding, even that is taken as one of the ground. Still then, that part we have already complied with. Whatever the work executed by the petitioner has already been paid. And the remaining the works to be paid, the remaining work which was not billed at that relevant point of time has been billed after carried out the joint verification. And that has been quantified, even if section 70 is applied in our case, still then the payment has to be made by the respondent department through escrow account, which has been entered into between the parties. That part, even petitioner has received the amount, whatever we have already paid for the work executed by them, that has been paid through the escrow account. So same way, we wanted to pay the amount through escrow account. But even section 70 is, even if it is, my lord, my another, my lord, way of submission is, if section 70 is approved, benefits we have already is, my lord, section 70 is applied in our case, benefits we have received. Moreover, my lord, V1, my lord, the execution of the work that we have already received, my lord, and that has also been paid, my lord. And the remaining amount which was not billed at that relevant point of time has been billed now. My lord, this comes to the figure, my lord, 11 crores and above, my lord. After deduction, it comes to 3 crores, my lord. So therefore, my lord, even if section 70 is in other way, my lord, applicable, my lord, of course, we are ready to pay the amounts to the, my lord, the petitioner, my lord, through, my lord, the respondent number 6. That is the, my lord, the whole submission.
Yes, what is your reply?
Well, so far as this escrow account was concerned, my lord, that was for our convenient. Escrow account was open with the respondent number 6, and we, my lord, 97% will go to me and 3% will go to him. But after the payment have been, my lord, sent by the BRO to that account, he has violated the terms and conditions, and he has, my lord, taken off the entire amount. So we had approached the BRO directly that this is things is happening, I am executing, this has been happening. And for that reason, your lordship will find, my lord, in terms of clause 4.2.2, the BRO by letter dated 31/10/2023 at page, again, my lord, this I have already shown, but then again, my lord, lordship will kindly see once more, my lord, 110A, my lord, 110, my lord.
Page number?
Lordship, my lord. Page 110, my lord.
Yes. The next are U1.
U1, my lord. We have, my lord, I have filed representation before them that he is doing these things, escrow account, he is violating the terms and he is not paying. So therefore, BRO by this letter directed the valuator to pay me. They did not comply, nor did BRO taken any action subsequent thereto. Whereas clause 4.2.2 clearly says, in case the principal contractor do not pay, then BRO may intervene. Our representations are there, my lord. Representation dated 2010-2023, page 109A. All these things, my lord, thereafter, my lord, on this letter had been issued on 31/10/2023. So now our prayer, your lordship may kindly see, my lord. Prayer, my lord, will see at page 33.
Yes.
Respondent number 3 shall not be directed to issue work completion certificate to the petitioner for the said project to the extent of 49% of the available scope of works executed by the petitioner. Well, there is a provision, my lord. After completion of the work to certain extent, now here I was allowed to work for 49%, and I have claimed for 49%, but they are disputing. So therefore, this 49% would not be, it will be the percentage of work that I have executed. Whatever, my lord, that is 26.1 up to 24, my lord, after joint verification taken, the entire work has come. Whatever percentage, they should issue me a certificate. That will help me for, my lord, participating in the further tendering process. So therefore, my lord, these subcontractors, my lord, under these big contractors, they work. That is the whole aspiration is this, my lord. The source of, my lord, livelihood, my lord, comes up, my lord, because with this credential, they can submit in different tenders as a, my lord, independent contractor. Now 49% may not be, because it become disputed. Though we are saying 49, they are saying, my lord, less. Whatever to the extent, my lord, that certificate should be issued, my lord. Then secondly, my lord, respondent number 3 shall not be directed to release the bank guarantee submitted in connection with the said project and further should not be issued. This is, as I said, my lord, the entire amount of the bank guarantee was deposited by me, and this court also considered, my lord, the documents which is lordship will find, my lord, page 41. it is to confirming that the above mentioned BZ has been issued from the account of namely Messrs. Peto Dumpen Enterprise, which is issued for Messrs. Velesa Private Limited for the works, namely construction and upgradation and so and so. So it is an admitted from my account. This BZ has been prepared and it was deposited in the so far as the contract is concerned. So therefore, this court taking note on 5/1/2024, taking note of this, direction was issued, don't encash it. So it's still that is lying. That is it. 5/1/2024. So that is still intact. That may kindly be released to me, my lord. Then, my lord, the third prayer is respondent authorities shall not be directed to release all the pending bills for the work executed by the petitioner directly to the petitioner account without imposing any liquidated damage and upon so and so. My lord, we are not claiming anything. My lord, my friend has said whatever action there they have already paid. Whatever you have paid to the extent of SPS 6, you have paid. Whether there is any dispute of apportionment between me and respondent number 6 is a separate issue. We are not claiming for that. But those pending bills, that has to be paid to me. So now, which has been according to them, it has been assessed at 11 crores and odd.
And what about deduction?
Deduction, this liquidated this is covered by the contract agreement. They are free to execute and recover from them. It is not of my fault. Lordship has seen the termination notice. Clearly says 26.7% work has been done exclusively by the subcontractor, and the principal contractor did not do any portion of the work. But for his fault, well, maybe suffered. And where is this contract that subcontractor fails? In that case, payment will not be released to the or deduction will be made from the subcontractor. There is no agreement. That's what, my lord, I'm pressing on this section 70. Works here. It is not that they are remediless. They are Union of India, BRO. They can realize all this amount from the Velesa. It is also multinational company. Their assets are lying everywhere. Had there been an agreement between me and BRO and it would have been governed by that liquidated damage, etc., I would not have claimed. But here there is nothing, and particular facts shows that I am not at all in fault. So therefore, my whole submission is that this amount, whatever admitted, that has to be given. The BZ has to be given, and Lordship will give me a liberty for any disputed amount remaining. For that, we'll have a liberty to approach the MSME or civil court, whatever. So far as the other amounts.
Well, just to clarify the one aspect regarding the payment of the.
In the other case, they have already encashed the bank guarantee. That is the. So that has my prayer in that petition is to refund the BZ amount. Here for release, there for refund.
In WBC number?
186.
186.
196. Well, just for a moment.
196 was on a different context. That was I have challenged because joint verification was not done. In the meantime, they had floated a tender. So therefore, I had approached this court challenging that tender. If the tender is floated or finalized, the very evidence will go. In the meantime, the joint verification has been completed, and there is an interim order for which they have filed the 200. So therefore, my lord, since entire matters.
In that petition, you have nothing to.
And now, so far as that prayer is becoming effective. 196. 196. 196. Yes, well, this has become infractions. Well, because I have challenged the NIT that they have perhaps already finalized. Then second is for joint verification that they have done. That was the basically two tender grievance.
Nothing survives.
Okay,
we'll close it.
Malad.
Yes.
Malad, just for to clarify the, my lord, regarding BG amount, my lord. Threefold barrier, my lord, lordship has already seen. This is one of the ground wherein, my lord, petitioner is claiming for the releasing of the BG, my lord. My lord, that aspect, page, internal page number 197, my lord. Annexure B, my lord. Of my lord, the additional affidavit, my lord. Day before yesterday, my lord, this was filed. Just termination payment, my lord, just
Additional affidavit.
my lord. Additional affidavit filed by the Union of India, my lord. Termination payment, my lord, the entire things are being governed by
Yes,
this
2nd
contract,
of December.
my lord. May I read, my lord, clause 23.6, my lord, termination payment, my lord.
23.
23.6, my lord. This is all extract copy of the, my lord, the contract agreement, my lord. This is part of contract.
Yes.
My lord, one thing is clear, my lord, whatever the amount BG is, whatever may be, my lord, deposited by the petitioner is on behalf of the petition respondent number 6, who is the principal contractor, my lord. The principal contractor is Malaysia, my lord, the respondent number 6, my lord. Petitioner is, my lord, the stand in the soldiers of the, my lord, the petitioner respondent number 6, my lord. So that part is also, this part, my lord, the contract agreement is also covered. Termination payment, my lord. Upon termination on account of the contractor's default under clause number so and so, the authority shall, my lord, authority, my lord, here tendering authority. A, in case an appropriate the performance security, additional performance security, if any, and the retention money, or in the event the contractors has failed to replenish, or the extend the performance security or additional performance security, if any, the claim amount stipulated in clause number so and so is agreed predetermined compensations to the authority for any loss, delays, and the cost of the completing the work and the maintenance, if any, my lord. My lord, what does it mean is, my lord, my understanding is, my lord, the BG amount, whatever the additional BG, whatever the amount deposited for the execution of this particular work, if, my lord, the whosoever may be principal contractor or the subcontractor fail to execute the work, my lord, then the amount will be, my lord, directly profited by the, my lord, department. That is, my lord, the another. And regarding, my lord, since lordship is dealing the entire things, however, my lord, if, my lord, the lordship may kindly, my lord, the considers my IA, in the event of, my lord, dispose of the entire matter, my lord, this IA will go with, my lord. However, my lord, they are just,
That petition already, Lordship has held to infectious in connection which this I has been.
no, my lord, therefore, my lord, rightly pointed out by the London Senior Council, my lord, that IA was basically for the stay of the, my lord, the NIT, my lord. My lord, this honorable court has passed an order without the leave of the court. My lord, no, my lord, the contract shall be finalized, my lord. So therefore, my lord, entire thing,
If we are closing the rate petition, then
my lord,
we are closing the rate petition.
my lord.
So the interim order, whatever was there, will go.
My lord, interim order is in, my lord, the IA, my lord, connected IA, my lord. So therefore, my lord, if lordship, my lord, closing the entire things, my lord, that will cover up, my lord, the end of the justice will suffice. However, my lord, if, my lord, our IA is basically for, my lord, leave, my lord, granting of leave to ask to, my lord, the issue, my lord, the NIT, my lord, the responsive, my lord, the letter of waiver to the responsive bidder, my lord. That is the whole phenomenon.
Pardon, Mr. Jesus Lukia, and senior counsel assisted by Madam. Learned counsel for the petitioner, and Mr. M. Kato. Learned counsel for the respondent number.
My lord, 1, 2, 3,
1, 2, and 3.
3 and 4, my lord.
1, 2, 3, and 4.
My lord, I'm appearing for the respondent number 7 and item number 10, my lord, performer respondent, the bank.
Okay. Your good name, please.
A. Sandilya, my lord.
Learned counsel for the respondent number
7 in item number 10.
7. Item number 10. Argument concluded. Order reserved.
Malad, in another case, Malad, 80 repetition number 86 and 96, Malad. That Malad senior counsel has already pointed out that is Malad BG has been Malad forfeited, everything has been released, Malad. Malad, that in that aspect also, Malad, the calculation has also been done, Malad. The amount entitled by the petitioner is also calculated as which has been Malad annexed in the additional affidavit Malad filed by the Union of India. That he will Malad also covered, Malad. The amount required to be
They
paid by
also
the
joint
department.
verification done, but then figure is different than this. That is the difference. And the busy amount has already been encased. So therefore, my prayer is to refund the amount. For the remaining, my lord, for remaining disputed amount, my lord, I may be given a leave to approach the court, my lord.
I'm for respondent number 5.
Okay. Respondent number 5. Okay. Next item.
Development.
Lordship, I was supposed to get the instruction today, Your Lordship. May I kindly list this matter on Monday, Your Lordship? I'll get the instruction, Your Lordship.
Monday.
Yes, Lordship. 9th.
9.
Yes.
The long pending instruction.
Long pending instruction.
Since March, the
Might be
approval.
long, therefore, say it takes time.
Yes.
Heard Mr. Kosik, learned counsel for the petitioner. And Madam Basar for respondent number
1 and 2.
1 and 2, and Mr. Pada 3 and 4. Ms. Basar submits that the matter may be listed on next Monday, so as to enable her to obtain necessary instruction. There is accordingly allowed, rest is the matter on next Monday.
Lovely.
Here, my lord, there's a connected with petition. I am for the respondent, my lord, the bank. There's a connected with petition WPC 231, my lord. My lord, may take this with WPC 231 and may kindly fix on 17th, my lord, for final admission here. Oh, no. WPC 231.
As agreed by learned advocates of both the parties, recess will release the matter on 17th along with WPC number
231, 2024.
231, 22.
My lord, there is interim order may be continued.
Interim order for service shall continue.
Obliged.
15 or 16.
It was listed yesterday also, my lord. My lord, I have filed an IA, my lord. My friend, the petitioner side, my lord, he has said, my lord, read that, my lord, the entire matter may be disposed of, my lord. So I may not, I will not press the IA, my lord.
Yes, my lord, we have all exchanged our my lord, pleadings by now, my lord. So instead of hearing the main IA, my lord, the entire case could be disposed of, my lord, your lordship, with the permits, my lord.
How much time you will take?
My lord, I can't be specific, my lord, if you look. Once.
My lord may, my lord, submit the facts, my lord, but I will argue on the maintainability of the repression, my lord. If maintainability, if I succeed, my lord, then on merit, my lord may not go, my lord. If my lord permits, then I will argue first, my lord, regarding maintainability of the repression.
It would be kind of reversing, my lord, but it's always
Since Mr. Tapo is for the petition,
Yes,
he has the right to be.
Yes, my lord.
Let him begin first.
Yes. That's there, my lord. My lord, otherwise, my lord, the grievance of petitioner is not against the private respondents as such, as on date, man. It's against the, my lord, the state respondents, man. This is regarding tender, man. So, what we are seeking in this writ petition is, lordship, that in the technical bill, on the ground that we have violated some clause of the tender, my lord, our bid has been rejected in the technical manner. So what we are seeking here is that because they have not specified the exact ground, they have simply quoted the clause under which the petition tender has been rejected. Now, Lordship, if Lordship kindly takes up the writ petition, the first annexure Lordship will starts from, well, I'll not deal with others, but the specific which is relevant matter. This notice inviting tender is of 3rd July 2024, matter, page 30. Lordship. Lordship got this is page 30. Matter. This is the NIT. This name of work, Lordship, L026 Sario to Saratakang. The Lordship will find in column 6. The total amount is of 1767.32 lakhs. That means 17 crore 67 lakhs. This was the tender amount. Now, if your Lordship comes to the annexure, next annexure, my Lord, that is starts from annexure 4, page 116. This is the opening of technical B, technical first part, 116. Your Lordship will find in page 117. So, Lordship will find last 6 evaluation of bids, Lordship. Now here, the name of bidders on left side, Lordship, responsive 1 and 2. There are private respondents here. And petitioner is the serial number 4, Tayo Enterprise. Now, in all the cases, Lordship will find the bidders, the rejection ground of rejection, Lordship will find attracts 4.4B, I, 4.5B to 4.7 I. In all the cases, not alone the petitioner, all other bidders. Now, Lordship will find what is 4.4 B of this. It's in the page, Lordship, page 35. Otherwise, madam, I have already elaborated in my writ petition also. Lordship will, if Lordship will finds it with this voluminous in that one. In the page 9, my lord, I have elaborated verse 4, para 9.
Yes.
Lordship, the para 9, 4.4B, small b, states that each bidder must demonstrate availability for construction work either own or on lease or on hire of key equipment stated in the appendix to ITB, including equipment required for establishing field laboratory to perform mandatory tests and those stated in the appendix to ITB, the petition respect. Malad, this was the ground that, this ground is that I have not submitted that one. Whereas in my next annexure, I have submitted the required numbers of instruments which were needed for the tender. I have uploaded, it starts from page 119 onwards. Onwards, Lordship.
Hmm. Yes.
And 4.4B, Lordship, para 10, is states about technical person qualification experience as per clause 9.1. That also I have uploaded.
At page number?
My lord, may see the key technical persons is that page 119. It starts from there. Others, my lord, I by an additional affidavit regarding the equipments, I have annexed those one, those mal. Otherwise, they are not denying this one, the respondent, state respondents. Key equipments. Now, the next ground is 4.4I. What this clause says is, even though bidders meet the above qualifying criteria,
At
if
page number?
page paragraph 11, Lord.
11.
Yes. This is the third ground. 4.7, a small I. The petitioner responsible submits the third ground for declaring petition be non-responsible for attracting clause 4.7I. What the clause reads, even though the bidders meet the above qualifying, if it meets everything, Lord, all the qualifying, it has submitted everything, then also there is this clause is there. Qualifying criteria made misleading or false representation in forms, a statement, affidavits, and attachments submitted and proof of qualification requirement. These are the things on which allegedly they have disqualified Malad. But if Lordship has seen the impugned technical evaluation, they have simply quoted the clause Malad. Whereas nowhere they have stated what kind of statement, misleading statement has been made, which equipments has not been provided, Malad. Nothing has been given in that clause. So we file a representation before the responding authorities, my lord. And as per the SPD, they ought to, before opening of the financial bid, my lord, they should have addressed the grievance of the petitioner. They have not done so. So what we are seeking in this writ petition is, my lord, and in the case of private respondents, they also have several defects, But those things were ignored by the respondent authorities, and they have been made qualified in the prize bid. Your Lordship will find that one in Lordship will see annexure which we have submitted, Malad. I'll just take a look at the. The representations page 6, 172, Malad, annexure 6. These are the representations given by the petitioner.
Yes.
Now, Lordship will see what
This
where
is
the,
not yet been disposed of or disposed of?
no, they ought to have disposed of this first one
They have
before
not disposed
opening of the financial bid. They have not done. And open the financial bid and declare them a private respondent herein as qualified. Lordship will find one on page 176. Annexure 8. Now here, MS Capital Enterprise has been declared as a lowest bid and work has been awarded to MS Capital Enterprise, page 176. Now what we are simply praying is that, my lord, no substantial the documents or allegations have been made in the impugned evaluation, technical bid evaluation that we have committed such error or anything, ma'am. Despite that, they have disqualified us and they have qualified the other two private respondents. Now, if your lordship sees the affidavit filed by the state respondents, I will leave everything but the private respondents. What we are saying is let them also get qualified for the financial bid. We are not against them. What we are seeking is that we also should be made eligible to participate in the financial bid. That's the only prayer we are seeking. We are not seeking from this honorable court that this honorable court should direct the respondent authorities to award us the work. What we are seeking that our case also should go to financial bidding also. They cannot reject arbitrarily like this. Now, if lordship sees the affidavit of government rest because we are not seeking that private respondents should not go to financial bid. That's not our case. We say let them also go, but ours also should go. Now, your lordship will only take up the government's affidavit, lordship. What kind of explanation, if your lordship will kindly say? Para 7, man. The answer starts from this.
Affidavit in opposition filed by respondent number
1 to 5.
1 to 5.
State respondent.
Yes.
Now, lordship will kindly see the main response is a para 7, man. Now they have given here that what were the defects that were found in our bidding. Now, lordship will kindly say para 7. Small Roman 1, lordship. As per list of key construction equipments uploaded by the petitioner, he had claimed to own 3 numbers of trucks, mounted water tank, Tata, New Holland make, but there was no relevant documents to support his claim of having or owning 3 numbers of water mounted truck. Same is not annexed in the writ petition to substantive evaluation committee has rightly rejected his bid on aforesaid ground, man. First of all, what kind of ground it is, man? The ground is that the petitioner has not annexed that document with the writ petition, man. That is the ground they have stand they have taken, man. They have not taken a stand that it was not uploaded in the bid. That's not the stand, man. What the stand is that it has not been annexed with the writ petition, man. The number of pages with regard to vehicles and other machinery, it contains 127 pages, man. In the bidding, that one, in our bidding, man. So, for brevity, my lord, definitely we will not annex everything, but it will be so bulky, my lord, writ petition, if we annex everything. And instead of the respondent authorities knows that we have uploaded, everybody can see those, even the private respondents, my lord, every bidder can see what I have uploaded. And I can also see what other bidders have uploaded, because this is online, my lord. Nobody can hide anything. This is the ground the state respondents take that I have not annexed. Whereas by additional affidavit, I have annexed all those documents. In the reply to this affidavit also, I have annexed those documents. Now, second matter, same ground. Although petitioner submitted 3 numbers of pneumatic tire roller, same is also not annexed with the writ petition to substantiate his claim. As such, technical evaluation committee reject his bid on aforesaid ground. This is the second ground. Now, these 2 grounds, lordship. It has not been annexed with the writ petition. It is not that it has not been uploaded in the bid. That is not the case. If I have not uploaded, I would have admitted that it was my fault. They could have rejected. But the ground is that it has not been annexed with the writ petition. That cannot be a ground, man. They should say I have not uploaded, or it was insufficient.
Okay.
Now, your lordship will third para 8, the reply. Now, why they have rejected? Now we come to know, madam. They should have disposed our representation, madam. We would have come to know on what ground our case has been rejected. Now they are coming with this affidavit. Para 18. With regard to the statement in paragraph 10 of writ petition, the answering deponent begs to state that though the petition submitted key technical personnel, but the salary scheme corresponding monthly EPF subscription does not tally each other. Now, I don't know what, by this statement, I can't make out anything. I can't make out anything. Whether they want to say that I don't have EPF, they are not saying that. How the EPF, Manoj, and salary slip can tally each other, that I don't know how they can mesh those things together. Salary is totally different, Manoj. I submit the salary slip, that's totally different. EPF registration is totally different. How it can tally each other, nobody knows, Manoj. The state respondent has to explain what kind of statement they want to make in this paragraph. And second, Lordship, moreover, Lordship may kindly mark, some of the employees' education qualification documents bear barcode, but it could not be scanned. This indicates that affidavits are arranged fictitious, misleading, and thereby affected clause 4.4b to 4.70. This is a stand, what I also can't make out what kind of stand this is, Malad. That indicate the respondent authority want to say they scan the documents, some of the barcodes, they could not make out whether it's original. This has not been reflected anywhere. Now, Lordship, regarding this very contradicting statement has been made in other writ petition, same kind of tender, same thing. We have said in those the other writ petition number 356, Lordship. It's in the list. It's 356. I urge your Lordship to kindly see the affidavit of government of 356, Lordship.
Yes. Is it listed today?
Yes. 356, that's a writ petition number.
Today's item number?
Only part of the government affidavit, but nothing else. There's only one paragraph from that affidavit. Paragraph 12, Lordship, of government affidavit. Yes, of that government affidavit, paragraph 12.
Yes.
In that, Malad, we have said that the employees' education, qualification, etc., were not uploaded by the other firms, Malad. Therefore, that it should be disqualified. That was our stand, Malad. Now, kindly see para 12, Lordship, Roman 2. They address in a technical qualification information right, and there was no issue as per evaluation committee, Malad. Now, next 3 plus. That's as per appendix to class 4.b, small b, 2, the same ground under which we have been disqualified. No, kindly read this. No specific education qualification requirements mentioned for key personnel for supervisor. So the furnishing of education qualification of site supervisor is not substantial defect, Malad. Only scan copy of payment certificate of employees, either acquainted roll, master roll, or any other valid payment certificate not later than 3 months old is required only. Now here what they say, the documents are not required, madam. Education qualification documents of the employees, madam. It's not required. This is a stand what they have taken in this writ petition. Now in our writ petition, what it says that though you have uploaded the qualification certificate of your employees,
We cannot scan barcode, though we scan, we cannot authenticate it. This is the stand they have taken. So therefore, your bid is disqualified. Two totally different yardsticks. In one writ petition, it says it's not at all required. So it has been made responsive and he is qualified for financial bid. How they can take two different kind of stands in the same kind of writ petition, the same kind of tender. These all are for, though projects are different, the same on the vibrant village program, all the tenders. Here the stand of government is the qualifications not required, the certificates in 356 months. Now in our this present writ petition, they say, because you have the certificate, they even don't say that I have not uploaded. If they say that you have uploaded, but the government cannot authenticate it, you bring the original, then matter would have been different. The employer could have brought the original certificate with the authorities before the committee, tender committee. They have not done. Now here they come, why they have rejected? That two, first of all, the ground is that you have not annexed it in the writ petition, the pertaining to vehicles. Second is that we could not ascertain because the barcodes in some of the certificates could not be scanned. These two grounds they have rejected now. Can it be possible, arbitrarily rejecting our cases, on these two grounds?
Okay. Yes, Mr. Soikia.
Therefore, it is the, first of all, the state respondents has to make the stand clear why they have rejected. The private respondents cannot say why my case has been rejected or not. It's the state respondents.
May I please, my lord? Admittedly, my lord, by the MP on order, my lord, his technical bid was rejected, and my lord, the financial bid was also opened, my lord, but a recommendation has been made for consideration, my lord, at page, last page, my lord has just seen, my lord. But my lord, work order has not been issued because of the stay from this honorable court, my lord. Till listing of that case, my lord. Last listing was on 26/11/2024, my lord. Now there is no, my lord, stay as of now, my lord. My lord, the reasons will be best answered by the authority concerned, my lord, the employer of the tender, who is, my lord, issued the tender, my lord. I am for the respondent number 6, my lord. I have been engaged by my dear friend, my lord. So, my lord, my submission is that, my lord, the writ petition is not at all maintainable in this form, my lord. My lord, kindly for a moment, come to page, my lord, the cost title of the, my lord, the petition, my lord.
You are for respondent number
6, my lord.
private respondent.
6, my lord.
So who is for the state respondent?
State.
Okay, let me first.
My lord, the petitioners is trying to stress only on one or two grounds. There is three altogether on clause 4.b, capital B bracket B1, 4.4B2 and 4.71. So he stressed upon other clauses. Only even out of these three, if one is attracted, is also sufficient ground to reject the technical bids. If it is 4.7, that is 4. Page 37 of the petition. Even if though the bidders made the above qualification criteria, they are subject to be disqualified if they have made misleading or false representation in form affidavit statement, affidavit, and attachment submitted in proof of qualification requirement in his bid documents. Of course, my lord, if today, if they are in the matter may fix tomorrow, I'll submit all the documents. In his bid documents, he has submitted there is no pending case. But there was a there is no ongoing project. He have not submitted the ongoing commitment list of ongoing commitment. Whereas in our affidavit we have furnished the work order. He is undergoing a construction of the secretariat at Raga and one more school. That ongoing project has to be disclosed. There is a even in a appendix there is a column where he has to disclose. Now in his affidavit, he has said that that is different. Similar nature of course, in a similar nature of work, I have executed similar nature of under road construction. That is different case. Ongoing commitment, he has to furnish this much work is undergoing under my firm. That part he have counsel. So this is also one of the most major ground. Unless that is not there, it is difficult to calculate the bid capacities of a bidders. That is one of the ground which his firm was rejected in technical evaluation.
You have referred to page number 37 of the writ petition.
Yes, this is the one of the condition. Misleading information.
Which one?
Misleading
Point number.
writ petition. This is the condition SBP of my affidavit.
In your affidavit.
My affidavit.
No, you are referring to page number 37 of the writ petition or your affidavit?
The page 37 is the ground clause under which which can be rejected, which one of the ground which his bid was rejected, 4.71, giving misleading information. Then my affidavit annexure A, page 249. This is the ongoing project under his firm.
Point number?
Annexure 1, A, 249 page, my affidavit in opposition. Or the clause, my lord, point number 4.7, sub clause 1.
49. Page number 49. 249.
249 is the contract awarded to MS Tayo Enterprises in other places. So this information ongoing, it is still ongoing, this project. That information has not been furnished in the bid documents. So this is someone's the separation or misleading information.
So this information was not furnished.
Not furnished in the bid documents. Then my affidavit, my learned friend is page 420, 243, para 7, 1. As per list of key construction equipment uploaded by petitioner, he had claimed to have owned 3 numbers of mounted water truck Tata New Holland make, but there was no relevant document support his claim of having or owning 3 numbers of the mounted truck as per the SBD documents. Now he has left out and the next part he is trying to claim. Just I want to show that as per our rejection, he also petitioner also could not annex in the writ petition. That what I want to state it in this. Same is also not annexed in the writ petition to substantiate his claim as such the technical. This part he is taking stress. Other part he is keeping quiet. In the bid documents, not the there is two. One is numbers of the machinery which he furnished is used to give in one set of paper. Then that has to be list of the document machinery which he have submitted has to be substantiated by the documents. Registration of the vehicles, insurance cover of the vehicle has also to be submitted. He have given the list of the machinery he have owned, but that has to be supported by the registration number, then insurance coverage. Here in this case, there is no such document of all the three machinery which he have claimed to submitted. So here also insufficient. Second part, that may be my typical mistake, although there is submit number writ petition. Herein also documents, if my laws permits, I can also produce the document tomorrow. This part, it is not in his petition. Documents of the rollers. When he claimed that he has submit all these documents, that has to be substantiated with his petition also, my lord. Whenever if he comes with naked bodies, so how will this court will do robbing exercise that I have punished this if it is not supported by his petition? This has to be supported by his petition. So court cannot do a robbing exercise to find out whether he has submitted document or not. So there is a reasonable ground on which his technical bid was rejected. And regarding submission of the representation, my lord, now it has become patient. All the unsuccessful bidder used to submit representation today. By tomorrow, they will file petition. Even the authority, even before that representation reached to the concerned authority, they used to come this court. That is going on. So it's very difficult to dispose of their representation also on time. Before they dispose the representation, they used to approach the court. So that cannot be ground to.
Okay.
And otherwise also at this stage, financial bid already open. Now because of stay order, this project is a very important project. This bordering to China. This vibrant village scheme is only means for the international border area, which is bordering to China. And this is very important infrastructure developments project. So my lord is aware of that in all, there are so many cases, catastrophe cases where the Honorable Apex Court has said, in infrastructure development activities, courts should be very cautious in interfering with the tender matter. So the committee, expert committee, technical evaluation is done by the expert committees. So in view of my humble submission is at this stage, since because of the stay order, the execution of the work is already delayed. In case of Arunachal Pradesh, hardly 2 or 3 months is a working season. By February, it will start raining. Vibrant village program. So
yes, Mr. Sokia.
My friend has submitted before the Honorable Court that my lord, grounds of rejection has been clarified, my lord. Other than that, my lord, the project is of my lord very important, my lord, because it's a vibrant place, inter-place connection, road connection with the border area, my lord. And my lord, NIT was my lord issued in the month of August, my lord. And my lord, the requisition was also filed in the month of August, my lord. Now it is December, my lord. Because of the interim order, my lord, the my lord, road has been stopped, my lord. Road has been stopped, my lord.
No, you are challenging the maintainability.
Maintainability of requisition, my lord. My lord, the requisition is not maintainable in this form, my lord. I will kindly see page 4, my lord. The first title of the requisition, my lord.
Yes.
The petitioner matter.
Mm.
MS Tire Enterprise, Renting Complex, Borapani, EO Successor, District Successor, Bapupani, Arunachal Pradesh, represented by his attorney, Sri Arun Lanyon, son of Successor. The read petition is being filed, the petitioner is the matter, the farm matter, proprietorship farm matter. And the proprietor is not before this honorable court matter. And the proprietorship farm does not have any legal entity matter to sue or to file a read petition matter. It is the proprietor matter who can represent the matter farm to file a read petition before this honorable court matter. Now the proprietorship farm has been defined, madam, in item 4, my lord has seen the judgment, madam, the Divasaki has also produced a judgment, madam. And before that, my lord, my lord, kindly you can see paragraph 2 also, my lord. Paragraph 1, my lord, is also important, my lord. To substantiate my objection, my lord. The petitioner is a farm. Research class such and such. It has participated in the tender process, my lord. And paragraph 2, my lord. The present read petition is being represented by its attorney, madam, who has been duly authorized to file the present petition on behalf of the petitioner, madam. The present read petition is the matter farm matter, the proprietorship, proprietary matter, not the proprietor. And the matter, kindly see the affidavit matter at page 18, madam. Serial number 1, page 18 of the affidavit matter. Serial number 1, madam. That MS Tayo Enterprise is petitioner in the present read petition, not proprietor. The farm is the read petitioner. Paragraph 3, madam. The proprietor of the farm has duly authorized me to file the read petition. The proprietor is not before this authority. So, this read petition is not a government.
Is there any bar that proprietor, no, the attorney cannot file a read petition on behalf of a farm?
No, madam.
Proprietorship.
No, madam. Proprietor has to be there, madam. The attorney can sign the matter affidavit, madam, on behalf of the proprietor, madam. He cannot be a petitioner, madam, in the petition, madam. I will show the judgment also, madam. I have the confirmation.
So does no, is there any rule in the Guwahati High Court rules?
No, madam.
To that effect?
Because of CPC, madam, and the partnership acts, madam.
CPC.
CPC and the partnership act.
Is it provided in the CPC?
Yes, madam. I will come to that judgment itself, madam. But before, madam, come to the CPC, madam, I will, my lord.
What is the judgment?
Judgment, first judgment, my lord, the definition of the proprietorship, my lord, 2007, 5 SSC. 2007, 5 SSC, 103, my lord. Raghu Lakshmi Narayan versus Fine Tubes, my lord.
10.
Paragraph 13, my lord. The proprietorship has been defined, my lord. May I read, my lord? The distinction between partnership firm and a proprietary concern is well known. It is evident from the Order 30 Rule 1, my lord, and Order 30 Rule 10 of the Code of Civil Procedures. The question came up for consideration also before this court in Ashok Transport Agency versus Awade Kumar, wherein this court stated the law in following terms. A partnership firm differs from a proprietary firm of proprietary concern owned by an individual. A partnership is governed by the provisions of Partnership Act, though a partnership is not a juristic person, but Order 30 Rule 1 CPC enables the partners of the firm to sue or to be sued in the name of the firm, madam. Next line is important, madam. A proprietary concern is only business name in which the proprietor of the business carries on the business. A suit by or against a proprietary concern is by or against the proprietor of the business, madam. not by the proprietary, my lord. Proprietary is the farmland. In the event of, my lord, this is the, my lord, just to show, my lord. Now, my lord, this has been, my lord, reiterated in the, my lord, the recent judgment of the, my lord, Supreme Court in Vinayak Consutum Dubey versus Jayasri Padmakar Bhatt matters. One of author of this judgment is, my lord, one author is Justice Ujjwal Bhai, my lord, recent judgment, my lord. This has been, my lord, relied upon in this judgment also, my lord. The earlier judgment of 2007, my lord, at page 19, my lord. The Raghu Lakshmi Narayan has been relied upon, my lord, here also, my lord. So, my lord, go put the judgment, my lord. Thereafter, my lord, just to show that, my lord, the farm has no legal entity, my lord. The place of judgment of the, my lord, Delhi High Court, my lord. Here. At paragraph 6, my lord. Just to show that, my lord, the property doesn't have any legal entity, my lord. Paragraph 6, my lord. In the light of aborted analysis of the legal position, one thing is clear that so far as the property concerned, it does not have any legal status. In the case of property, concern wants to file a suit, it has to be in the name of the proprietor, not in the business name. And lastly, my lord, our honorable court has also dealt with this. Dealt with this matter, my lord, exhaustively, with my lord, Peno Enterprise versus State of Arunachal Pradesh and others, my lord. And paragraph 2, my lord. Here also, my lord, a tender matter, my lord. Paragraph 12 onward, my lord. May I read, my lord? On a conjoint reading of the aforesaid provisions, my lord, here, my lord, Power of Attorney Act has been dealt with, my lord, and the CPC was, the provision of the CPC was also dealt with, my lord. On the conjoint reading of the aforesaid provisions, this court is of the considered view that by virtue of powers conferred under a power of attorney, an attorney can only represent the principal as an agent, which is purportedly done by virtue of the power of attorney. The power of attorney does not give an authority to attorney to substitute himself as a litigating party, so as to enable him or authorize him to file writ petition in his own name by substituting himself as a petitioner number 2 in place of the principal. Here, my lord, the farm was petitioner number 1, my lord, to farm represented by, my lord, the proprietor was petitioner number 1, and the respondent number 2 was the power of attorney holder, my lord, in this case, my lord. This court is of the considered view that if the proprietor of the petitioner number 1 farm is Sri Bamang Manga, as projected by the Annexure 1 to the writ petition, which is an office order of the Office of the Chief Engineer, then it was otherwise open for the petitioner number 2 to be representative of the said proprietor. In that event only, proprietor of the petitioner number 1 would have been arranged as the petitioner number 2, who can validly represented by his attorney, my lord. It says, my lord, the farm should be petitioner number 1 and petitioner number 2 ought to have been the proprietor, my lord. And the attorney could, my lord, file the, my lord, writ petition by signing the affidavits, my lord, not as a, my lord, petitioner, my lord. In the present case in hand, it is seen that instead of the proprietor joining the writ petition as a petitioner number 2, the attorney has substituted himself as a petitioner number 2. In this case, my lord, he represented himself as a petitioner number 2, the power of attorney holder, my lord. Therefore, except being the agent of the proprietor, the petitioner number 2 cannot be said to have an independent right to maintain a writ petition in his own name. In view of the above, the ratio of the judgment, paragraph 13, my lord, in view of the ratio of the judgment of this court in such and such, as well as such stand as a bar for maintainability of the present writ petition. The petitioner number 2 can, if the power of attorney permits, represent the petitioner number 1, but by virtue of power of attorney, this court does not find any material to show that the notwithstanding the same is not being filed in this writ petition. There is nothing on record to show that by virtue of the said power, the petitioner number 2, namely Sri such and such, was authorized to substitute himself as a party in this writ petition in place of the proprietor. The principles of the CPC, Civil Procedure Code, is followed in filing of the writ petition. Therefore, under principles of Order 30, Rule 10 of the CPC, the firm, the petitioner number was authorized to maintain a writ petition in his own name on being presented by the proprietor. And it was open for the proprietor to maintain a writ petition to the attorney. In my case, my lord, in this instant case, my lord, the proprietor is not before this honorable court, my lord. The firm is before this honorable court, my lord. Represented.
Mr. Tapo, how do you respond to his submission?
This matter is already settled by this honorable court, our own Guwahati High Court. What it says, the proprietor, there should be an explanation why the proprietor.
In which judgment?
Because this was not raised in their affidavit, so this was not raised in the affidavit. So, how I will know, they will be raising this particular point. It was not there in the
Real
affidavit.
issue, my lord.
I agree, my lord. Because I didn't know this issue will crop up. But there is a judgment because I did not come prepared for that kind of argument. So there should be an explanation in the writ petition why the proprietor has not been able to come to the court, my lord. That is the judgment of our High Court.
Yes,
there should be an explanation. That's
in the
there I
extent writ
admit,
petition, my lord, there is no such explanation, my lord.
I admit to that position, my lord. Frankly admitting that, but that's the judgment of our own High Court.
Okay, come prepared tomorrow. Then
Yes,
we'll
definitely, my lord, regarding that.
we'll keep the matter as.
Otherwise, my lord, my brother, the government side, which he has said, my lord, that similar nature of the nature of some kind of existing work has not been given, my lord. That is already there in clause 12 of the SBD, my lord. The tenderer should only give the existing similar nature of work, my lord. The respondent which they are showing is a construction of buildings, my lord. Whereas this tender is for construction of road. I can only give regarding construction of if existing work is there. Not other if I'm electrical work, if I'm doing my lord. I cannot show it here in this tender. That objection is totally absurd objection. From the respondent side, the affidavit is clear, they have definitely violated the tender clauses.
Heard Mr. Pitapal, learned counsel for the petitioner. Then Mr. R. Sakia, learned counsel for the respondent number 6, and Mr. Z. Tarak for respondent number 125. Respondent number 7. Your good name, please. Okay. Harden part, list the matter tomorrow.
The rest of the matters also, if you pray lordship, because same is pertains to this similar all the vibrant village items. Item number 24. Yes,
these are order matters which will come up for NCC some other day.
Yes.
After
No, the lordship, they say is urgency, because here they show urgency because they stay. In other cases, there is no stay. That's why we are in urgency.
23, I am appealing for the respondent of 5.
My lord.
It can be other.
My lord, may I pray kindly, can it be on Monday, my lord?
Next Monday.
Monday.
So other matters also, lordship, I'll definitely stress
Item number
24, 23, 23, 24, and 25.
23, I am appearing for respondent of 5. Here, my lord, we have filed our affidavit yesterday possibly you would like to file reply on it.
No, my lord, definitely we are not against the, as I said, madam, not against the private respondent as such. We are against the decision of the government, madam.
So let it be on Monday then.
Yes, it will be in the first week of January.
My lord, that bill already got delayed, my
Anyway,
lord.
what he has challenged in that repetition is his rejection of the technical bill.
That's why, my
Now,
lord.
by this time, my lord, the work order has been issued in my favor.
The-
So now he has not challenged my work order, my lord. He has to overcome that rejection first.
My lord, all those things are, we'll take care of it, my lord. Let the matter we get disposed, my lord. That's the urgency we need, my lord. Either way, my lord, the matter needs to be disposed, my lord.
My lord will fix in the first week for disposal.
No, my lord. It will already, because they were caveators, my lord. First of all, they were caveators, my lord. They have taken so much of time in filing affidavit. Intentionally, because there was no stay, my lord.
Right now, my
That's why.
friend says that they are not against me, it is against the government.
No, but
So if the government has
Mr.
already.
Kosik, you can appear pro basic.
yes, my lord. We are not alleging any, my lord. Tuesday, Lord. Yes, my lord.
May I please, Lordship? Your Lordship, I make mention item number 21. I have filed an IA yesterday.
Order passed.
23, 24 and
26 also.
23, 24, 25, same order.
Same.
20,
Okay, then Tuesday.
Yes, my
July.
lord.
Tuesday.
Yes.
23, 24 and
26 also, my lord. Item 26.
36,
26, 26,
26.
26.
Okay.
That's not, we are not there, my lord.
Tuesday.
26 was the interim order may be confirmed.
Okay, 26 interim orders.
Your Lordship, item 21,
Yes.
this may be taken tomorrow, Your Lordship. This is transfer matter.
Okay.
Urgency.
31 tomorrow.
Applies.
Yes.
Remove
32. When do you want? When do you want? Next month, say.
Kali hoga, kali kar lega.
Yes.
My lord, item number 19. Well, item 10, my lord, 10 of this month.
When do you want?
On 10,
10.
10,
Okay. 10.
December,
My
my
lord.
lord, December.
Item number 17. This matter may be taken up after 1 week, my lord, because in respect of respondent prior, service is still awaited, man. After 1 week, man.
After 1 week. Okay.
My lord, item number 10, 15, my lord. On my lord 10, I may not be available, my lord. Can it be on 9th, my lord? Item 15, my lord.
Item 15 on 9. Okay. Take down. Yes.
My lord, item number 33, my lord.
Yes.
Item number 33, my lord.
Yes.
My lord, it may be fixed on 10 because due to paucity of time, my lordship, it will take some time for hearing, my lordship.
On 10th.
On 10th, my lord. At 2, it may be fixed because it will, every time it may.
After 2 weeks.
My lord, on 10th, it may be fixed, but if possible, my lordship, at 2 p.m., it may be fixed, my lord, for hearing, my
Okay.
lordship.
Okay. Okay. At 2 p.m.
Highly.